appeal in the matter of the claim on the application of Thakrar and Secretary of State for Justice.
Yes, Mr. Armstrong.
Good morning, my lords, my lady. My name is Nick Armstrong. I appear on behalf of Mr. Thakrar with Aidan Wills, who's behind me. Mr. Thakrar, I'm delighted to say, is successfully on the link. For the Secretary of State, you have Mr. Grodzinski, KC, you have Miles Granderson and George Molyneux on their side. Can I do a little housekeeping?
Yes.
Just to check that you've got things. You should have a core bundle and a supplementary bundle. You should have an authorities bundle, which in hard copy is split into two, but you may be working electronically. I just want to check whether you are, because that might affect how
I'm not.
You're not working, so
I think the lady is.
okay. There's a mix. I'll do my best to use divider numbers as well as page numbers. There is a bundle of additional authorities, which was produced by the Secretary of State yesterday. I hope that has all reached you too.
I'm not in hard copy, given to myself.
Thank you. Thank you. And that is it for the moment. It's not impossible there'll be additional authorities during the course of the day, but there's no intention to go beyond those at the moment, so far as I'm aware. My lords, my lady, can I just? We are sitting at 10 each day, I know. Can I just check lightly what time you're intending to sit today? I know it's 3 tomorrow, if we get there.
Well, normal time today, 4:15.
4:15.
But we must finish by 3 tomorrow.
Yes. The reason I
express the pious hope that we might not still be going at 2:59 tomorrow, but we'll see.
Well, I hope we're not. We'll see. The only reason I raise it, I'm hoping this is not going to become an issue, is a facility has helpfully been made available to us to seek instructions and have contact with Mr. Thakrar. You'll understand that having contact with Mr. Thakrar isn't entirely straightforward. He has been told today that he is only being produced for court between 10 and 4. That's not much use to us if we need to speak to him after 4:15. But the court, hopefully the prison will have heard, and certainly we have heard that we will need something after 4:15. So I hope that message will get through, and we'll deal with it if it doesn't.
See how we're going. If there's a natural break in the argument around 4, that'll be fine by us. But we're rather in counsel's hands.
Yes, indeed. But at the moment, I think the intention is he will be taken from there, where the video link is, back to his cell at 4. So he won't be available after 4. But if that becomes a problem, I may need to raise it. But
yeah,
Sorry, no. By 4, I should be on my feet, and if I have to stop at 10 to 4 or something, or 4:45 to give time for Mr. Armstrong to speak to his client, that's totally fine.
Thank you.
Good.
There is my loose intention, discussed with my learned friend, is that I will speak until about 3:30 today, and he will take over if I need that much time. I may do. I don't at the moment. No. And then there will be. He will go on until about 12:30 tomorrow, I think, and then I'll reply. So we should be finished on time. That's our broad intention. Can I just also flag this? I don't know if you have this issue. I am, of course, going to be inviting you to allow the appeal. The consequence of what then happens is a very live issue for Mr. Thakrar in particular. I am, subject to the court's view, going to say if you are allowing the appeal and are persuaded that it contains errors of law, then you will that you hang on to it and resolve it yourself rather than remitting it back to the High Court. The reason why we are minded that way, subject to the court's view, is obviously the very long delays that Mr. Thakrar has encountered, and the fact that there's still the lawfulness or otherwise of segregation has an ongoing impact for him even now.
Is that agreed? That position?
Sorry?
Is that agreed?
No. I haven't heard from Mr. Grodzinski. I've taken instructions recently on that, and that's what we ask the court to do.
You say we've got the material to do that, do you?
You haven't quite got all the materials that were below, but you've got enough, and you've certainly got enough.
Where is he currently situated, and under what conditions?
That's a slightly complicated question. He is in HMP Whitemoor. He has until Friday remained in segregation, which is a cell not on the CSC unit in Whitemore. It's away from the unit. I am told, and I just do this on instructions, and I'm doing this.
It's a designated cell.
Yes.
Away from the CSC.
Yes, indeed. I am told that he was moved, or has been moved on Friday. Have I got the?
The shaking of the head behind you.
Let me just check again.
The client's shaking his head.
My client is shaking his head.
Yes.
Right. Okay. Mr. Thakrar will tell me if I've got this wrong. He was instructed to move on Friday. He raised questions about the circumstances in which he was going to move, how he was going to move.
To move to where?
From the designated cell to the unit itself. He would still remain effectively segregated, is the intention, because they like to do a phased release from segregation. He would be moved on from there. He asked questions, he asked explanations for, before we do this, can I have an explanation as to why this is being done, how this is being done, and what my regime will look like in the new place, because how much exercise you get, association, etc., is a very big issue for him. His world has shrunk to such an extent that matters of those sorts of detail are very important to him. Having asked those questions, he has not been moved, and he has been subject to an adjudication, I understand, for refusing a lawful order. He says he hasn't refused to go. He hasn't refused to go. He hasn't. He has simply asked for reasons and explanations to what he's doing and what the new regime will look like. That is a process that happened on Friday, so our instructions are very recent, and I got another email. I'm speaking on my memory of an email that I saw about 10 minutes ago to tell you that. Can I ask Mr. Thakrar to nod on screen if that's an accurate account of what has happened? Okay, I may need to get some more instructions, but I'll do it.
Not totally inaccurate, but
So that's where, but he
Change was proposed on Friday, which
changes.
hasn't happened for reasons which would take a long time to explain.
Indeed. And at the moment he remains in segregation, and so far as I understand, he will remain in segregation even if he moves to the CSC unit proper, because they will want to phase a gradual expansion of associations. That's my understanding. Even when they move you to the unit, they keep you on a single unlock for a while. They may keep him within a segregated cell on the unit for a while. That's where I'm really getting to the outside edges of what I understand, and there's a limit to what I can do.
and he's been at Whitemore since the transfer from Manchester, where he
Yes.
was on
True,
having some association on the CSC unit there.
true.
Was any explanation given at the time for his move from the CSC at Manchester to Whitemore?
I can't remember. We would need to take instructions on what happened at that stage.
Okay.
Do we know when?
If there is an explanation and it's somewhere in our files, I'd be grateful to see it.
Yes, I will.
Thank you.
We'll investigate that. Thank you. So that's where we're at in relation to disposal. That's what we seek, but as I say, subject to the view of the court, it's just a concern about time. Can I? Yes.
Can I just check what the court would like to know, in the sense that I understand my learned friend says if you allow the appeal, certain relief he would be capable of being given by this court. Because the period under challenge ended a long time ago, my submission would be, even if you were in a position to redetermine the question of proportionality for yourself, all you could grant would be relief as to the past periods. There isn't before the court a detailed evidence from both sides as to what's happened since the period under challenge. If the court is asking both sides to provide evidence in relation to that interim period, obviously that will take some time to put together.
No,
No.
it is because it's been mentioned,
Yes.
because it was produced for the judge below.
Yes.
I am just interested to know whether there were reasons given and if so, what they were
Noted money.
for that particular transfer.
Noted.
Because it was a matter that the judge below considered.
Yes.
She received further submissions about
Yes,
it.
indeed. Thank you.
Yes, and there's no dispute from me that if you were to decide the matter for yourselves, then we would be focusing on the time as it was before the judge below. I'm not inviting you to look at matters where we've got limited evidence anyway.
Sorry, you dropped your voice just then.
So work out where my point is.
That's only for fraud.
We would only be concerned with declaratory relief, for example, in relation to the past period up until the date of the hearing before Mr. Justice McGowan. I'd have to confine myself.
We're strictly speaking not concerned with what has happened since Mr. Justice McGowan's judgment. If there's anything which we need to know as part of the history, particularly if it's not factually disputed, you tell us, like where he is now, adds coherence to the narrative. But we're not going to embark on, for example, the rights and wrongs of the dispute which occurred last Friday.
I agree.
Although you do say, don't you, that what happened afterwards shed some light on the lawfulness of what happened before?
Yes, I do. I mean,
Yeah.
particularly in relation to Article 8. The point being, there's a limit to, and I accept there's a limit to how far I can take this, but it does put into issue, just raises a question mark as to if it was necessary to hold him in segregation for this length of time and have no possibility of association for all of that time. How was he very shortly
That's
after
why I
the
joined Milady in thinking it would be helpful to know precisely why he was moved from Manchester.
Yes, I agree. We'll do our best on that. All right, thank you very much. Can I just start with some preliminary observations and a summary of where our claim is. I want to sort of make a headline point, and I'm going to take my ground slightly out of order, slightly in the way the Secretary of State has done it, because I'm going to address. I do need to spend a little bit of time on the facts in order to, and that's focused on, slightly unusually on appeal, but that's focused on grounds 4 and 5. So I'm going to do facts and then grounds 4 and 5, and then come back in. Our headline point is, if, sake of argument, the Secretary of State is going to do to our client that which has been done, which is hold him in a CSC and additionally in segregation for as long a period as was 2 years and is now, as of Friday, 5, then that requires very great care and intense scrutiny. Yes, of course, lots of things will be said and have been said about Mr. Thakrar and why people should be very concerned about him. But this is a part of the prison system that's inevitable when you're dealing with CSC prisoners. And it is a bit of the prison system that requires, we say, a light to be shone on it because of the serious consequences of what flows. It's been recognised, and I will look at the authorities in a while, but I mean, I imagine the court already has the point, that even short periods of segregation are recognised as being harmful. This is segregation within a CSC, within the Category A estate, and for very long periods of time, and the consequences of that are very real, and we'll show you a little bit of evidence about how that has impacted on him, and you'll see signs of it. All of that is all the more important, we say, where it is, of course, serious violence that got him in CSC and in segregation in CSC in the first place. But it is a matter of at least some note that when that was subject to the scrutiny of the Crown Court, he was acquitted. And I accept what Mr. Justice McGowan says about that below. And it's not the end of the matter, and it's still a risk management decision about trying to understand what was happening there has to be carried out. But it is a feature of this case that when he gets independent scrutiny by a court, he very often succeeds. And there's another reason why I bring that to your attention now, which is one of the things that is said about him is that he makes a lot of complaints, he makes a lot of claims, and that's annoying and a management issue, and he encourages others to complain or tells them how to do it. And no doubt that is annoying for staff, etc., etc. But I mean, A, he's allowed to do that, and you would want him to raise his grievances by lawful means, and B, when he is successful in those things, including getting declaratory relief and substantial damages about Article 3 breaches because he's been attacked on racist grounds by other prisoners, including on things like property matters, he does, at least quite a lot of the time, have a point when he gets to the court, and he does tend to succeed. So in those circumstances, it does require care, proper focus on what the justification of this treatment is, and it requires that from the decision makers, and that means the actual decision makers in the case, which is here the CSC Management Committee, and we'll talk about who they are and how they function in a while. And it also regretfully required it from the judge, and my submission is, again regretfully, he didn't get that from the judge. 21 months is a very long delay. There are a number of errors and very clear errors throughout the judgment. At least 2 of them were conceded by the Secretary of State. Secretary of State says they're not material, but they are, we say. And in a case where it is as intense as this one, materiality is an easier bar for me to overcome, because these things are turning on small matters and marginal matters. And if I say that she got something wrong below, then I say that I succeed. That's why I'm going to spend a bit of time looking at the decisions themselves. I won't do all of them, but I'll do a few of them to show you how it works, and to show you what was necessary to examine the justification in that anxious context, and what, regretfully, I say the learned judge below didn't do. So what I'm going to do...
Can I ask you a question, just rising out?
Yeah, of course.
Very helpful. When you use the word segregated, are you always going to use it in the same way? Is it a term of art? And if so, what does it mean?
It's a removal from association, and it's a removal from an association with peers.
Just a minute. So it's removal from association with peers. Is that the that's how you're using the phrase?
Yes.
Is that how it's commonly used in these proceedings?
By peers, you mean other prisoners?
Yes. So he doesn't get, there's a relaxed, sort of informal exchange with peers. He gets contact, and my learned friend emphasises this, he gets contact with people who come to the door, although that's very restricted. He gets, he's in his cell 22 hours, he gets exercise alone, and the only people he has contact with people by phone, that's true. There are, of course, the limits on that, PIN numbers, restrictions, whether the technology works, those sorts of things. But it is...
Does he get PT contact in the gym when he goes for exercise on his own?
Trainer, doesn't he?
There's a trainer with him.
Yes, I don't actually know whether there's a trainer there.
He's shaking his head.
But he exercises alone. He takes meals in his cell, I understand. He's in his cell 22 hours a day. He has phone calls with those people for whom he's on cleared numbers. He doesn't associate, he doesn't mix with other people. He can have contact by shouting to people out the window. You'll see references to that occasionally, but that's it. And as you've heard...
And family visits?
Yes, you can get
And obviously legal visits as required.
Yes.
So I was asking about the word. So
Yes.
when you use it, and you're all going to be using it, are you, in the same way, meaning lack of association with other prisoners?
Yes, and there, but yes, indeed, and there are. I mean, umbrage has been taken at the use of phrases like solitary confinement, because he's not locked in a cell having contact with nobody at all ever. But it's a very restricted regime, and it is the loss of association and the beginning, ability to talk.
I just wanted, all I wanted to know is to be clear that this was a word which you were all going to use in the same way, meaning lack of association.
Yes.
Any association with other prisoners.
Yes, and there are. I'll come to it in a moment, but I don't think there's any dispute about what the regime looked like at the time before the judge. The 22 hours, exercise alone, meals alone, only contact with professionals, and then family visits when there are family visits. So, my lord, my lords, my lady, what I'm going to do is I'm going to do the facts. I'm going to do grounds. I'm going to do a little bit on the framework in a moment, but then I'm going to do grounds 4 and 5. What I'm going to say is, when you look at the decisions that are actually made, we win in common law terms, because sometimes, reasonably frequently, there isn't a second decision. There isn't a CSC and a separate segregation decision. When you look at the decision in detail, they are not giving separate consideration to the second bit. So whether you should be a Rule 46 prisoner and whether you should be segregated. So that's the first, and Rule 5, if they do consider it, they don't give sufficient or adequate reasons. So that's a common law ground. I will say that for largely similar reasons, although the analysis is slightly different, we also succeed then under Article 8. So I will take Article 8, which is grounds 6 and 7, after that. So I'll go, and this is, so, and then I will say Article 3 and see if we can get to that threshold as well. And based on what we say is, and I know it's a high threshold and it's a difficult, it makes my life is harder on that ground than it is on the others. But in relation, but we say we get there because when you look at the other material, the other circumstances which are not in dispute, and then you add in the failure essentially properly to think about it, we say we can get to Article 3 because that is degrading. You haven't thought about this properly. You're not considering the impact on him and the long term, etc. And then finally, I will deal with ground 8, which is the Article 14. I will slot in some of my sort of points about ground 1 and burdens of proof and so on, and along the way. That's probably how I'll deal with it. But I can come back to that in summary if I need to. Can I then move on to just briefly on some law on the framework? And I'm going to do this relatively lightly for now. Can I just first of all remind the court, as I'm sure you're all fully aware, the point here is to Secretary of State has to justify both the placement in the CSC and any removal from association within the CSC, which can be through segregation in a designated cell outside the CSC unit, or can be what's called a single unlock within the CSC unit, so you're just not allowed out with anybody else. It is now common ground. See the respondent skeleton at paragraph 42.1. That both need to be done. Both stages need to be done. We have flagged in our skeleton at an earlier stage in the detailed grounds of defence. It seemed to be at least implied that it wasn't being done because, and I'll just give you the reference, page 251 at paragraph 87. That's paragraph 251 of the core bundle. At paragraph 87, says, well, it's very difficult to try to do that.
On the whole, we prefer to be taken to something. Otherwise,
sorry,
when you've gone, you'll wonder what its significance was. So 251. Right.
Yeah, it's thank you very much. Thank you, Molly.
These are the detailed grounds of defence.
Yeah, the page 251. And you will see paragraph 87 dealing with what was then our ground 4 about whether they'd considered it at all. They make their submissions, and then at paragraph 87, in all the circumstances, it's very difficult to see what separate consideration should have been given to the claimant's segregation, and ground 4 is accordingly unfounded. And there's just a
Is that an observation about principle or about the facts of this case?
Facts of this case.
All I would say is, at the hearing, it was common ground in front of Mrs. Justice McGowan that separate consideration had to be given to whether he was permitted to associate with other prisoners. And those paragraphs of the detailed ground didn't contend otherwise, and even if they did, which they didn't, at the time of the hearing, that was common ground. And has now been confirmed, as I think my learned friend will probably take you to, by Mr. Justice Sheldon in a case called Awale, which hasn't been appealed.
I mean, it's definitely post-Awali, it's clear that that is the position. Mr. Awali is, in fact, Mrs. Justice Ellenbogen. So that's we will go to that in some detail because that's the only other case that looks at both CSC and segregation, and it's relevant in at least 2 ways.
Has this all been? This hasn't been considered by this court.
No. And the Abu is Mr. Justice Sheldon, which is the case where an Article 3 breach is found in following segregation within a separation centre. Which is an extremist unit, radicalisation unit, which is similar but not exactly the same. And if I need to look at the differences between the 2 regimes, I will. But
well, let's look at the case law later. At the moment,
it's
you're setting out
yes.
your stall.
Yeah, absolutely. I will just say this now in parentheses. One of the things that we say, and this is relevant when we get onto the discrimination ground, is that, and this sort of slightly equivocal, what other consideration could we give, is when we look at how the CSC-MC works, it doesn't focus in the same way as it does under Rule 45 on the separate question of segregation. When we look at the decisions, we will see that the way the meetings are set up is or appears to be a focus on whether you should be in the CSC at all. And we'll see that, and you see it quite clearly from Awali. And we think that, just putting this in parentheses, one of the problems here is those instructions, those arrangements have had the result that the CSC MC tends to think about where you should be. Should you be in the CSC unit, and if so, which CSC unit, rather than segregation within the unit, which is more of a local matter. It needs to be dealt with by both. But there is a bit of a history here, we think, that is about. That's why you've not really addressed your mind to it as well as you might have done, and we'll come back to that in a moment. There's support for that in a couple of the references, and I'll show you that later. But that is where we're at. A lot of my learned friends' submissions on this and whether there was a decision at all is, well, you can decide it by implication. You can, it was before them, they knew where he was, so you can take it as at least implied that they gave consideration to it. And we say that's not enough. Given the consequences of this, you need more than that. You need specific focus. And when we get into cases like Borgas, Shahid, and Ramirez Sanchez, you'll see that again. But I want to focus just highlight another point about that. Is there's another feature to this, which is when we look at the reasons and when we look at what is required by way of reasons, particularly when we're looking at it in the Article 8 context, so arguably also common law, it is your reasons have to get better as time goes on, because you may be relying on at least one reason or one big reason and a couple of small reasons. We don't know what the split is between them, and working out what the reasons are is the problem, or is part of the problem. But if you are going to continue relying on the same reason, you can't just trot it out in the same way in every decision, because over time the consequences of this are so much greater, and you have to properly ask yourself, and be seen to be asking yourself, whether the consequences of that, the impact on him, continue to be justified. So something that might be justifiable in April 21 when he goes in, might well not be justifiable, and you need to address your mind to it in April 22 when he's been there a year. So that's another feature of that. And just in order to key that up, can I now show you some authority? If I may. And I'm going to start with Borgas. Most of this is reasonably uncontroversial, I think. It's important to have rooted, which is in volume 6 of the authorities bundle. And I'm going to go to page 114, is where it starts.
Tab 6.
Tab 6, yeah. And this is a Rule 45 case about segregation. There's no, that which is required to justify segregation in that context is the same. This is a common law decision. It's from July 2015 in the Supreme Court. It's about, its focus is on procedural fairness, and the reason why you provide reasons is for procedural fairness reasons, and the court will be familiar with all of this in order to say, this is what we're thinking, do you have anything to say about it? But it's also, we've just flagged that the need for reasons is never just about procedural fairness, it's all about ensuring that the court can see that relevant matters are being confronted and taken into account, because reasons provide a discipline and structured decision making, improve better decision making. So, and you see all of that, we say, from the key paragraph is paragraph 100, which you will page 152 of the bundle. I'm going to anchor some of this now. It's paragraph 100. You see the sidelining on the whole page, but in particular 100. Prisoner's right to make representations is largely valueless unless he knows the substance of the case being advanced in sufficient detail to enable him to respond. Then you see the first line of paragraph, so you must therefore normally be informed of the substance of the matters on the basis of which the authority of the Secretary of State is sought. There is then, in that case, you need to explain to him the segregation was based on, in that case, an assault. And then paragraph 102, I just want to flag because it gives some support to what I say about reasons needing to improve over time, even in the common law context. Similar criticisms apply in Hussein's case. He'd been provided with information as to the basis on which he was believed to have assaulted another prisoner. It was not explained why several months later his suspected responsibility for that assault was still considered to require segregation, not as a punishment but for the maintenance of good order and discipline. So time matters as part of that. And we will be saying as we go through, you will see it's mostly about non-engagement, but is that something that can still be relied on throughout? But there are also other matters that Mr. Thakrar would have wanted to know, which is, does the Secretary of State still rely on the indirect threat to the probation officer in 2021, in April 2021, and other matters, an alleged encouraging others to assault a staff member in August 21, and indeed, and we'll see this, to what extent is the Secretary of State relying on the mistaken belief, particularly from early 22, that he nearly, January 22, that he needed to be held in HMP Belmarsh, where he could only be held in the designated cell, because of civil proceedings in the London County Court by then had succeeded. He was never going to be produced to trial there. And that seems to be a mistake on the Secretary of State's part, which never finds its way into the bit of the decision that is communicated to Mr. Thakrar. So, and I'll show you that in a moment, but those are the things where you need to confront it, and if you are relying on these other matters, you need to tell him so he can say things about them. So that's essentially where we're at. I hope all sort of uncontroversial matters. But I'll now show you Shahid briefly. This is an Article 8 case, but it's decided just after Borgas, and this is at tab 7.
But what do we get for purposes for your present argument from Borgas? The paragraphs 100 to 102 seem to me to be mainly about undisclosed reasons.
Yes. You need to provide reasons, and they need to address the matters of substance, which say why you are making this, why you are segregating, so that he can respond. So it is just establishing an unsurprising, and the reasons need to be matters of substance and meaningful, is the way it's expressed. And you'll see later that that's how it's found its way into guidance that is given to those making segregation decisions in the normal Rule 45 context, not in the Rule 46 context. And that's, so at the moment I'm just relying on the common law to say substantive, meaningful. That's the common law position. In relation to Article 8, very similar, arguably a little bit further. This is another segregation case. It's decided just after Borgas. It was run on Article 3 and 8 grounds, and it failed on Article 3, but it succeeded on Article 8. And you can see that from Head Note 4 at the bottom of page 160. So maybe I'll just let you read Head Note 4 because it's an easy way into it for the reasons. So sorry, Head Note 1 fails under Article 3, is an interference with Article AFC Head Note 3, and then 4 is it's not proportional. I'm going to show you a little bit more on that in a moment.
This is the source of your submission, that the longer you keep somebody in segregation, the better the reasons have to get.
Yes, indeed.
Although you say that applies to common law as well, do you?
Yes, because there is an issue as to whether this is just Article 8 or does Article does the common law also require you specifically to consider that as a relevant factor? My submission is yes, because that's a substantive matter and it's becoming more substantive, and it would be surprising if it didn't. And because Borgas refers to, in specifically, you know, even are you still relying it sometime later on the fact? So I think that it might be slightly lighter under the common law, but I say that it's still there.
There are two aspects to, at least two aspects that I can think of relating to the amount of time, the increasing amount of time somebody's been held on segregation.
Yeah.
And that is firstly the impact on them, the increasing level of impact on them potentially, although we can find it so in Shahid. But secondly, there'll also be the aspect of the behaviour of the behaviours that haven't happened during that time, or the negative ones that haven't happened, or the positive ones that have happened during that time.
Yes.
That's another aspect, as it seems to me, of lengthy time, of extended
Yes,
periods
also.
of time, which potentially need to be taken into account and reflected in the reasons.
All of that, I agree, respectfully. Yes, I mean, it's, and there is an issue between my learned friend and I about what actually could the reason say, because if they're saying you're not engaging, we can't tell what your risk is, and that remains to be the situation. What else can we say about it? That remains our reason. But the position is changing because of the reasons my lady is referring to. It's getting, the impact is growing. I'll show you a bit of this in a moment. There hasn't been, the behaviour is different over time. My learned friend will say, well, he's being held in an environment that is expressly designed to avoid any violence, so you're not going to see any violence. But at the same time, you can see what is going on.
Yes,
And I'm
yet
not,
in the past, that hasn't prevented him from expressing views in a phone call that were worrying, or saying things to staff which were worrying.
all of that. And I'm not saying that those are irrelevant. I mean, I'm entitled to say that there has not, so far as we're aware, there's not been any violence. There's these, in all of the time since he's been in the, I think in the CSC, but it was, and there's, and those threats that are referred to, we'll get into this. You've got an indirect statement on a phone call in April 21, and then there's suggestion that you're encouraging other people to attack a female officer in August 21. There are particular problems with that particular allegation, but there are also, they're very quite a long distance apart. There's only two of them. I'm not saying that they're irrelevant, but you do need to think about them. And what we don't see is that being thought about with and communicated.
It's a sort of ongoing process of evaluation, is it? Or
Yes.
it's a renewed evaluation in the context of all the relevant information, which must necessarily include information about what's happened since the last evaluation.
And what you don't get to do, we say, I mean, I'm not suggesting any of this is straightforward. It needs proper thought, because the intensity of what you're doing is so severe, and you're at impasse. I mean, I hope he doesn't mind me saying, but there was a moment at the end of the hearing below where the judge went, "How long does this go on for?" And the answer from the Secretary of State was, "Well, can't say, but it's not going to be over anytime soon." It can't be indefinite. It does require, and if it is going to be a very long period of time, which it obviously now has been, it does require proper, intelligent thought that is recorded in reasons, because you're doing something that's so severe. And one of the things I'm going to show you is as relevant, and it's relevant to my point about what reasons should we say address, is Dr. Crasati, who's a senior forensic psychologist, and she's one of very many people who have seen him. The Secretary of State takes the point that they're one-sided questions. He's only been seen by people he's instructed, and he's controlling the information flow. And there's a bit of force in some of that, but also you've got to bear in mind you're dealing with proper senior witnesses from a range of backgrounds and a range of experience who know how to guard against self-reporting conditions, etc.
And are these reports subject to the usual expert declarations?
Yes, they are. Well, okay. Well, they understand their role. Because they're often advising in the context of the parole board when the CPR doesn't apply. They're not. But I don't. I think. I'll check. I don't think she's signed the formal declaration. But I mean, these are very experienced experts, and she is adopting views on things like PTSD that come from other experts. And she is sitting consistently with what we know happens to people in these conditions. So it's not like she's saying something very surprising. And one of the things that she says, and we'll come to this, is this is reaching an impasse, or has reached an impasse, and that which you are trying to bring about, which is movement, is actually being made worse.
Yes.
You're
You
digging in.
say that there is plenty of evidence, both generally and maybe particularly in this case, that the more this continues, the more it accentuates the conduct which is said to have led to it.
Right. And I don't know what the answer to that is, but I do say you've got to think about it.
Yeah. But also relevant is going to be, and I'm not sure that certainly for myself, I've not seen anywhere the full list of the conditions under which he says he would see a psychologist. But the existence of the existence of the reasons, or what those reasons are, may themselves give rise to some cause for concern.
Yes, I mean, my learned friend makes a lot of that. I mean, I'll deal with that briefly, and I would need to take instructions on. I mean, he has remained quite consistent on the conditions that he requires to work. My learned friend, I can take you through it if necessary, but my learned friend places great weight on what he says is this wholly unreasonable compact that Mr. Thakrar wrote in, I think, October 2019, that says, I want you, if you're going to deal with me as a prison psychologist, to agree to all of the following conditions. As my learned friend Skeleton says, those are conditions and terms upon which no prison psychologist could ever work. Now, we could have an argument about whether those are reasonable or unreasonable conditions. Some of what that does is says, he is, one has to keep in mind with this how long he's been there. He's been in a CSC for 16 years. He at the time of the hearing, he'd been in segregation for 2 years. He is, you'll see in the reports, he is very untrusting. He is very hardened in his position that things that he says even lightly get used against him, etc. And he also says, with some support, I've got PTSD and I am not going to engage in a room, which is a locked-in room, which is where he is a lot of the time, with people I don't trust. And he says that... And, you know,
But they've moved on from that now. My understanding was that in September 2023, there was an agreement that he wouldn't need to have somebody else in the room with him.
I have to do this on instructions rather than evidence. I'll be careful about it. He is not engaging with prison psychologists still, because the new arrangement is that he can only do that in a closed visit space, which means through a screen. So my understanding at the moment is he doesn't want to engage with a prison psychologist in what's called a closed visits area through a screen, because they are not people he trusts, and to be in a place with someone he doesn't trust in a very straitened circumstance he finds triggering. Now,
even through a screen.
That's what he says, yes. And it's what he's trying to do. And I understand, you know, it will be said that's just not a reasonable condition. But you also have to look at what look at where he is, look at how he's got there, look at what he's been through, and people like Dr. Cressati say, one of the things they say about him is, he's an intelligent man, he ruminates a lot. As he ruminates, he gets wrapped up into things like perceptions of injustice, etc. But he understands his own reactions to things. He does have quite good insight into how his own mental presentation occurs. And so he is, he sits there and goes, this isn't going to be helpful. I'm going to find this tricky.
How should this impasse be resolved?
We say by, it's not, I'm not the decision maker. My submission, what I say is...
How would good practice dictate for such an issue and impasse to be resolved?
With proper thought. And that's what I say that we have.
Well, obviously there's proper thought. But...
Yes, and I don't know where the proper thought would get, but where I think the proper thought would get is, if you look at things like the Cressati report, etc., and the absence of now concerning behaviour quite a long time, other than statements twice in 5 years. Well, certainly in the 2 years we were concerned with, is you would say, relax it a bit and see what happens. And what we're seeing is relaxations take place. There's a bit of a relaxation that has taken place in relation to this, and he said, I still doesn't work. There's a relaxation that takes place when he moves to Manchester. There may be a relaxation coming place that happened in a slightly odd bit of timing on Friday, 2 working days before this hearing. When those relaxations have happened, see Manchester in particular, they seem to have worked. So there needs to be a bit of the Secretary of State. You know, he is very locked in. He's got PTSD on his account, and he's got support for that proposition. He finds it extremely difficult. It is the Secretary of State who needs to either move and see what can be done and try relaxing the regime and think about an alternative, or explain why that can't be done and confront the fact that after you've hit 2 years, now 5, what do you what do you propose to do about this? And what we see is not enough in the reasons, and actually blank reasons quite a lot of the time. You can't go on.
But from the Secretary of State's perspective, why should your client be able to veto his being interviewed by government instructed psychiatrists?
Because he says he just wants to have, he wants trust in the individual because it is a feature of his post-traumatic stress disorder that says he can't deal with being in locked environment with somebody he doesn't trust. That's what he...
Are there a provision for some form of independent psychiatrist or psychologist to be agreed?
It's never been explored as an agreed third-party person. And I mean, one of the other things I just say about this on a pragmatic level is when you look through, I mean, we've got Dr. Cressati's report in there. So that happens to be the one I'm going to go to, and it's the most recent. But when you look at the list of people he has been seen by, he is being seen, yes, of course, they're instructed by solicitors for parole board purposes and the rest of it, but a number of them are people who, one of them is a view who's from the treating psychiatrist at HMP Woodhill at the time. These are people who either are or have been involved in the prison service. It's very difficult to dismiss them as people who are too partisan. However, a learned friend may talk about the level of instruction, the way that
Lots of experience about instructing single experts in all sorts of fields. That's not done here.
not been done here. It's not. The Secretary of State wants to be, as I understand it, the Secretary of State wants to send in own expert, instructed by the Secretary of State, and gets you to cooperate. When we go to the compact that he wrote in 2019, and I need to take instructions on whether that's still what he expects.
Can I just? I'm just anxious to address this at the moment. It hasn't until now. This is not a criticism of any friend. Been suggested that the answer to the impasse is some independently appointed expert.
Well, that was my suggestion, wasn't it?
It will indeed. I suspect, although I haven't taken instructions, that the Secretary of State would say, we have our own trusted experts, that they're not biased, they're just people who we have experience with and who understand how the prison system works. This is not litigation with an independent court-appointed expert. No. We are the risk managers. It's up to us to decide which psychiatrists to instruct, and it's not up to the claimant to veto that.
Yes, well, I understand that is your case.
Yeah, but the consequence of that is, the consequence of that, you sit like this forever, and in circumstances where...
Well, the defendant may be saying, that's your choice.
But he may also be somebody who is mentally unwell, because he has PTSD. He is also somebody who has become entrenched because of things that have been done to him by the Secretary of State, so he's just been generated like this. There is also case law, which we will go to, about even if one would oneself disagree with the line that he's taking or the conditions that he's seeking to impose, at least some of it is supported by evidence of people that he has instructed. And I should, by the way, be clear, my junior is making it, Mr. Wills is making me, it's not being instructed as a parole board. These are experts he's instructed in order to help with his management within the estate, in order to reform it, because he's not at parole board stage because his tariff is so big. Right. But and you will see if one goes to the compact, the things that he looks at is, for example, if I say something in my meeting with you that you don't like and thinks goes to risk, I want you to agree not to share it with somebody else without first consulting me. Now, because you may have misunderstood something I said. Now, when a friend says, that's not a reasonable condition, you've got to let them do it and risk assess on the way that they do, and they're a professional risk assessor. But his side of this is, I am a person who has suffered through this environment, and things that I am being taken out of context for all of my custodial history. And I want to at least get a right response before a tiny thing that I had said is completely taken out of context. I just want a right to correct before it goes any further. Or I want to, conditions like I don't want to have at the time, I don't want a discipline officer in the room with me while I do it, because I find that triggering. There are various, if you try to move me, if there is a proposal to move me whilst I'm engaged in treatment with you, I want you to oppose that on a treatment basis. Now, of course, he can't stop my learned friend can, you see the objection, it will come. You can't stop me doing that. If they want to move him, they want to move him. But his point is, look, if you want me to engage and do something I find difficult to do, and start talking about things that I find difficult to talk about, and talk about things that have a consequence because the psychologist then informs things like the CSCMC decisions, then I want, if I'm going to engage in that process, I don't want to do that, get to know you, only then to be moved to another unit because I'm within the dispersal estate and I'm regularly moved, and then lose the relationship and have to go round again and start again and build the trust again and the rest of it. So these are not irrational positions. They are positions that are taken as a result of his experience, as a result of his mental health, which he understands rather well as the evidence. And the Secretary of State is just, and the Secretary of State takes this sort of blunt position, which is your choice then matter for you. You're in the darkness forever, essentially. And that we say is not lawful, and that's the crisp point that comes about. I mean, we say if you're going to, he's taking a position that says he doesn't want to be assessed, essentially clinically, in that way for good reason. We say that's not a legitimate answer to just say stay in segregation indefinitely. But certainly, once you're hitting the periods that we are hitting, it needs to be done with very great care. When you think about all of the things that the court is now properly putting to me, what is the impact of this? Is this worth doing? Is the risk really necessary? Are you making it worse? Is he right about his PTSD?
Well, in other types of dispute, this would go to some form of dispute resolution. But the Secretary of State says, as I understand it, we are the decision makers, and it's not. This is not an area where it's appropriate.
Yeah.
I mean,
I say that's
putting
wrong.
it crudely, but that's what his case is.
And I am saying the Secretary of State needs to be much more careful and intelligent about this. And the Secretary of State has been in the documents, and one has to be careful. Where I understand the points the court is putting to me. Of course I do. And I understand the concerns. I understand the concerns of the Secretary of State. I hope that some of the answers that I give at least possibly are capable of ameliorating some of those concerns. But the point is, they are not being thought about by the decision maker, because the decision maker is just slamming the door and going, no, stay where you are.
Is it your client's case that if I had a process of some form of independent evaluation of these issues, I would accept it? What I don't accept is the fact they're not being considered.
I would have to take instructions specifically. These things move incrementally. He needs time to think about it, and that's why he does, for example, what he's done on Friday, which is I want to understand what's happening to me.
This is so exhausting for him and for everyone looking after him.
Yeah.
With every engagement is fraught with trust issues.
Full on head to head for years. It's just. And then see who moves first. But he has the answer. He, on his account, has got a disability and has got an explanation and has been locked in a CSCDC for ages and ages. The Secretary of State needs to be, we say, because that's what public law and certainly the Convention requires, the one that thinks most carefully about these things. And we don't see in the decisions, well, we reject Dr. Crosati for the following reason. Or what we actually see is non-engagement, non-engagement, non-engagement. And occasionally you've said something on the phone or you've said something to other prisoners which we don't like, or something to do with Central London County Court proceedings, and that it's just not good enough. That's where I've got a huge chunk of my case out. I'll see if I can slow down and just and fill in the gaps on that. I was just showing, but that's helpful, and hopefully we'll save time later because we've got into the point. I was in. Shaheed, and I just want to show you paragraph 76 of Shaheed, which is at page 188 of the bundle. And this is within the proportionality part of this. You'll see just above paragraph 74, and then it's paragraph 76, and you'll see. Authorities set out, and then it's this. The last sentence, valid reflecting the statement of the European Court is often repeated. For example, in the Grand Chamber judgment in Ramirez Sanchez, which I'll take you to, that's the better known as the Carlos the Jackal case. that the reasons for segregation will need to be increasingly detailed and compelling the more time goes by. And then, importantly, Lord Reed says this, the extra division commented that they had difficulty understanding what this meant. If a threat remained the same, it was difficult to see how greater detail could be given, and that's what my learned friend says. But what is meant, as it was difficult to what is meant, as it appears to me, is that because the actual or potential harm which segregation may cause to the prisoner increases the longer the segregation is prolonged, the seriousness of the risk of harm required to justify his segregation becomes correspondingly greater. In addition, the court will become correspondingly more demanding in scrutinising whether segregation is the only means of addressing this, given the increasing risk that segregation will itself cause serious harm to the prisoner. So that's back to the point that we've been discussing about wanting proper focus, think about alternatives. If, well, as the impact is growing, does the need for your insistence on the way he engages with psychologists ameliorate at all? And that, one of the reasons, of course, why you want that is because it ensures that this serious thing is done properly, if at all. But it also means that you are focusing on the fact that in principle there is going to come a time when you can't do this. So you are going to need to be thinking about the alternatives to this, because it's only with that discipline that the proper things are considered. Now that's a reference to Ramirez Sanchez, and I'm just going to show you that as well. That was an Article 3 case. As I say, it's a Carlos de Jacob case, and it failed on Article 3, but it succeeded in Article 13 because it's a convention case, and there was a lack of domestic remedy for a point. But the
Tab 20.
Tab 20, yes. Can I just, actually, just before you do that, can I just flag for you that paragraph 77, the following paragraph of Shahid, is also just referring to matters that we see elsewhere in Borgas about the serious risks to the mental health of prisoners who are subject to prolonged segregation are well known. There's no dispute about that. But yes, then page 8.
Factually, Shahid is simpler than the present case, isn't it?
Yeah.
This is, decisions were supposed to have been taken at a particular level after 72 hours and so on, and they weren't.
Yeah.
And there's no suggestion that this was any fault of Mr. Shahid. Okay, Ramirez Sanchez.
Yes, so that's at Authorities tab 20, page 818. And it's a long period of confinement, about 8 years at the time that the period they're considering, which is why I recognise that, although I think I can get there, I recognise that my Article 3 claim is more difficult. But the main passage is paragraph 139, is paragraph 139, which is at page 867. I just want to show you this so you have it. In order to avoid any risk of arbitrariness, substantive reasons must be given when a protracted period of solitary confinement is extended.
So sorry, which paragraph?
So paragraph 139, page 867. Substantive reasons must be given when a protracted period is extended. Decision should thus make it possible to establish, that this is allowing the court to scrutinise, that the authorities have carried out a reassessment that takes into account any changes in the prisoner's circumstances, situation or behaviour. The statement of reasons will need to be increasingly detailed and compelling as time goes on. It's also just worth, while we're there, because it makes the point I've just been making, flagging 145 and 146, which is just over the page.
Well, just reading on in paragraph 139.
Yep.
The final sentence: a system of regular monitoring of the prisoner's physical and mental condition should also be set up.
Yes.
That's being rather frustrated at the moment, isn't it?
Well, it is, but he's also. But what? Just assuming, for the sake of argument, that Mr. Thakrar is absolutely right. That the circumstances. I mean, for a long time, what he was objecting to was having a discipline officer in the room with a psychologist.
Yes, but that's removed now.
And that's removed. But it was the position at the time we were in front of the judge. I understand why my lady is asking me the questions about. Really, you can't sit in even a closed visit room through a screen and deal with a psychologist. He needs the trust to do that, and that's what he says. Now, we may raise an eyebrow at that and wonder why that's the case and think about that. But
No, I'm not at all surprised by that's the case. I'm troubled by how that gets resolved.
yeah, I understand. Well, but one of the ways, I mean, I'll show you Dr. Crosati in a while, but I mean, it's getting increasingly hard to resolve it. If you want him to move on it, he may be getting more entrenched, and it's getting harder, and you can't move without him issuing a list of questions about what does this mean, like has happened on Friday. But this issue about we don't know what the risk is, he has been seen by so many people over so many years, and the list of psychologists and psychiatrists who have seen him, including about PTSD, is very long. And my learned friend can say they're not instructed by us, etc., and there are other questions we would have asked, or the questions we would ask the questions differently, of course. And that may be a weight point, but it doesn't reduce that body of opinion to nil. It doesn't say you are deprived of information, there is no information as to risk. There is just different information as to risk. And you need to think about it.
Needs to be taken into account.
Yes.
Question.
Yeah.
I'm sorry, the points raised by the Secretary of State go to weight, not to admissibility, as it were.
Yes, and there is, I mean, and again, if I was in a civil trial here, you're making the point on weight to the judge, which would say, say Dr. Crotati, not the only person who says this about PTSD, for example, lists in her report that the prevailing view is PTSD, and there are a number of senior people who haven't got all this material in the bundle, but there's lots of people who say the same thing, but also saying that the impact that we are discussing is in line with the impact we know happens when you do this to people over long periods of time, and even sometimes quite short periods of time. So it's not like she is saying anything very surprising. So when you say, well, the letter of instruction is not all it could have been, and it's been written from a different point of view, and they've not got any material, that's a point that can carry some weight. So it's not a point that is going to, as I say, reduce to zero the weight that you attach to these reports. Given
this is a report. Who drafted the letter of instruction?
those instructing me, my solicitors.
And what was the Secretary of State invited to contribute to it?
We want an updated position so we can rely on it, and we will send it in the Secretary of State. We will try to persuade the.
I know you'll appreciate my background. This is all coming from a welfare jurisdiction,
Yes,
and these
yes.
things are done very differently. But we are concerned with welfare ultimately here, even in a very different context, aren't we?
I agree. And maybe something like that would help, but I am saying that the Secretary of State's position of going, no, you can't, not ever, we make the risk, we decide the risk, matter for us, you comply with our psychologist or no one at all, is A, not a lawful approach, because you've got as a public body decision maker to take into account all relevant evidence, but also it's not helping. it's just digging a deeper entrenchment, and the consequence of that would be.
Your first point there is circular, isn't it?
Sorry,
it's not lawful because it's not lawful for the Secretary of State to say, we want you to be interviewed by a psychologist instructed by us, and your client says, I'm not willing.
Well, I'm not
And
willing.
the Secretary of State is acting unlawfully by saying that's your problem.
I say at the very least it becomes unlawful over time. You have
And
to
the
do this
result should be what?
more careful consideration, thought about the impact, and I hope that careful consideration and more thought about the impact will produce a movement on the Secretary of State's part, which might result in some information that result in some more incremental movement, or it might result in something from Mr. Thakrar. I don't know the outcome of that, but what's the alternative?
I mean, if he were examined by a psychologist instructed by the Home Office who came to the same conclusions as Dr. Casciati, that might improve his legal prospects very considerably.
Indeed. Yes, and one, you know, the we can say that, and people like me can say that, but it's and the court can say that, but he is very one of the consequences of being where he is and having been there for as long as he is. This is where we are at, and the question then is, what is the solution to this? Which is what our lady posed and says. Well, what is the way out of that? And the answer to that is, I say, Lord, not this, not just dig in with a risk manager and get. You need to be more intelligent about it than they are being. And when I get into the decisions, you'll see.
What was the further paragraph in Sanchez?
Oh yeah, sorry. Thank you. Over to 145. The court nevertheless wishes to emphasise that solitary confinement, even in cases entailing only relative isolation, can't be imposed on a prisoner indefinitely. Moreover, it's essential that the prisoner should be able to have an independent judicial authority review the merits and of reasons for prolonged measure of solitary confinement. That would have been a court of protection overview, but we don't have that. It's JR at best. In the incident case, that only became possible in July 2003. And then the next paragraph would also be desirable for alternative solutions to solitary confinement to be sought for persons considered dangerous and for whom detention in an ordinary prison under the ordinary regime is considered inappropriate.
So do you say, what impact does that have, that first sentence have? The indefinite can't be imposed indefinitely. Do you say that that ultimately does have an impact on the Secretary of State's absolute power to dictate the terms of risk assessment?
Yes. Yeah. Or you know, and the immediate restraint is that you have to address it. So common law and Article 8 and Article 3. You don't get to do this unless you've thought properly about it. So that's your first constraint, so that you are properly justifying it and also satisfying a court in due course that you are properly justifying it. But also, the second restraint on that was there does come a point where, absent something very exceptional, you can't keep it up for years. The impact is too great, and that's where we break into the convention point, which is even if you've given all of the reasons, the court will then come to a point and will have to review those reasons and decide whether it agrees. Now that, as we get into Article 8, will be a question where the learned friend will make the submissions based on Brewster and the other cases about you defer to the expert decision maker, and the expert decision maker is the risk manager, and this is we know what we're doing. And I respond by saying, well, Article 8 does allow for a certain degree of that, but fundamentally the court is the decision maker. It just may respect expert views, as you would expect any court to do. But this is not a matter of high socioeconomic policy, of which there are matters that you don't know because we're talking about this is a pensions case or something. There's lots of matters before that's before the Secretary that you don't have before the court. We're not in that territory. We're in actually quite a court-orientated assessment here, which is about security and risk and the things that the court is used to doing. So the level of relative expertise is much greater here, I say, in relation. I'm forgetting the second half of the point, but in relation to those things, but also as we look at the decision making that actually takes place in this case, when you are being asked to respect the judgment that is being exercised by the Secretary of State, that is tempered by the fact that a lot of the time you don't have much of a judgment, and some of the time you don't have a judgment at all. So if you're going to have defer or respect, there's got to be something to defer or respect to.
So
which is
just thinking about it will not be enough. Ultimately, the Secretary of State has got to do something.
Yeah.
So if the individual digs their heels in and adamantly refuses to compromise at all, are you saying that ultimately there comes a point where the Secretary of State has to concede? I mean, is that putting it too crudely?
Might get there. Yeah, you might get there. I mean, it's not unlike, but I mean, I'm not. I'm a long way, maybe some distance away from that.
Well, 5 years. Well,
Well, you
5
maybe
years.
get it. I mean,
How long would your client have to be be segregated before that happened?
Well, I do say we're in that territory now, and were when we were before the judge, because actually, when you properly interrogate what he's done, I mean, there is things they don't know about him. You can see all of that, but there's not much there. And of course, you're going to want to do it incrementally and see how he gets on and see how he does on association. I mean, Dr. Krasati says you could release him into the main wing on her assessment of the risk that he presents. So we are in that sort of territory. you know, he is. I mean, it is relied on. I make this. You know, one of the things that they say they rely on, although it's not really in the decisions themselves, it tends to be in other evidence, is he's disruptive to the unit because he encourages other people not to engage when he is allowed to associate, or when he talks to people through the shout from the window or whatever. He's disruptive because he says things and he encourages people out to complain. I haven't got there yet, but I mean, one of the features of Mr. Thakrar is he's an intelligent man. He's a 9 GCSEs, he did A levels, got into quite a competitive grammar school. He's might be cleverer than the average, and he knows how to complain, and he knows how to complain successfully. But that's not a reason for.
Going back to my question, it is your case, is it, that there comes a point where individuals if they dig their heels and refuse to compromise at all, ultimately the indefinitely point means that the Secretary of State's got to concede. Is that?
Yes, eventually, yes.
I know that's a crude, reductionist.
But that concession is only taking out at the moment.
Sorry.
All I'm saying is that, I mean, I don't know if my lord remembers these. I think you may do, and certainly so. The immigration detention cases, for example, where you have complete impasse because you can't remove somebody who is, you say, dangerous, but because, say, it's Iran, you wouldn't want to be trying that at the moment, but say it's Iran and they don't ever produce travel documents, so you end up, you're detaining somebody pending removal, and the removal can never take place. There does come a point, is whatever the dangerous presentation of the individual is, you have to release. Now, that's a sort of similar, broadly analogous situation to this, except I'm not saying release him. I'm saying release him into the CSC. He's still in the prison within the Category A estate, within the closed prison estate, and. Just, you're not taking that much of a risk here. And the risk the other way is massive. You're deeply entrenched, the consequences of mental health, you're never getting back. You'll never get that which you're trying to achieve, which is rehabilitation and movement. And I just say that both common law and the convention require something different to this. And again, headline point, needs, if you're going to do it, lots of care and we don't see it. So that's where...
I think you're saying, aren't you, that the longer it goes on, the more creatively you expect the Secretary of State to think about the ways in which the condition could be ameliorated in some way.
Exactly. Think about the alternatives.
And to do that, in order to examine whether that process of increasingly creative thinking has been properly done, at the very least you need to see complete reasons
Absolutely right.
where everything has been taken into account.
Absolutely, absolutely.
To allow him or those who represent him perhaps to say, well, hang on, what about this?
Yeah.
Have you taken that into account?
Yeah.
We're talking at this point of entrenchment. We're talking little shifts, aren't we? This is like you know, cars in a narrow street where you just have to. Somebody has to move forward a couple of inches so that somebody else can move a couple of inches, so that somebody else can move a couple of inches, and eventually. It adjusts itself. These are not seismic changes, they're little shifts which may overall prompt forward movement.
Yeah, camper vans in Cornish villages, yeah, all of that.
You know, yes, he has a long tariff, but at some point the parole board will need to consider him for release, and they cannot do that without expert input from psychiatrists and psychologists, risk assessors. That can't be done without him having been seen by people approved by the parole board to do it. And at that point, conditions that at the moment his lack of trust sees him imposing just they're not going to work. That is not going to happen. And admittedly, that's still some time in the future, but anyway.
All of that. And my lady, that's probably a good moment for me to take you just to a Wally. And I'm going to come back to this again in relation to discrimination, but it's I just show you.
You're finished with Ramirez Sanchez.
You're finished with Ramirez Sanchez.
It strikes me that judgment, and looking at the majority judgment, it all seems to be going rather well. Ramirez Sanchez, and then in the final paragraph 150, they say, however,
yes,
you lose, even after 8 years.
All of that is true. Yes.
And under conditions of very much more severe segregation than we find here.
Yes, he was also. It's an old case, as the judge below says, but he's also Carlos the Jackal. He's sort of resourced in a way that Mr. Thakrar is not.
Okay, Awani, where's
so
that?
Awali is
Back in the first part.
back in the first one. Which is at tab 17. And the reason why this we say is an important judgment is just because it shows an example of it's the only other case where this regime has been considered. So CSC and segregation. Although one does need to flag that Mr. Awali was not in a designated cell. He was assessed as being suitable in principle to, there was a factual matter here, so he was assessed as being in principle suitable to associate, but he wasn't able to associate, they hadn't found a way of associating, so he was de facto removed from association as the prison service hadn't ensured that he had associates, and that was so that it was a de facto segregation rather than a...
Has there been an appeal from this case?
No, it's not under appeal. And that may be important given some of the points we're going to make particularly later on. So it's found that there was a de facto segregation, and I just want to make a couple of points at this stage. So first I'm going to go to paragraph 79, page 614. I'll come back to this in the context of discrimination as well, but it's just rejecting a submission made on behalf of the Secretary of State. That's halfway down that paragraph.
I'm sorry, was it? I missed the number.
Paragraph 79 at page 614.
Thank you. Sorry.
No, it's too fast. And you see rejecting Miss Hannett's submission to the effect that removal of association under Rule 45 is not analogous because it applies outside the innately constraining environment of the CSC. And this is just as Ellenbogen responds saying, well, if anything, that serves to underline the importance of ongoing review for a CSC prisoner. So it's all the more important to be intense in your scrutiny in this context because you've lost so much already. And I'll come back to that point elsewhere. But then you look at paragraph 90 with the ground 2, which is where you need to be. And what she does, I'm just going to ask you to quote Orgas.
Did you just read 89?
Yes. Paragraph 89, I'm being asked to read, I conclude that other than between 29th of January and 16th of March 23, during the period to which these proceedings relate, the claimant has been removed from association within the meaning of Rule 46, during which period it's common ground there was no review or renewal by the CSC of the direction given by the defendant under Rules 46.1 relating to his removal from association, rendering his removal unlawful for that reason. And then it's into ground 2, quoting Borgas. Then at 92, sentence, all of the above principles apply with equal force to decisions taken under Rule 6, in which removal from association bears the same meaning, so tying the two regimes together unsurprisingly. And then can I go to just giving you examples of the reasoning. Paragraph 97, what she's doing is she's going through incrementally each of the stages. Why can't he associate with that prisoner? Has he been given sufficient reasons about that prisoner? Could he have been transferred to Whitemore? So we've got 97, 98, 99. I'm not going to go through these in detail. But it's a detailed analysis of each stage and saying, what's he being told at each stage? And it's analysis I'm going to do with you in a moment, if I may. And it's a decision, regretfully, I say the judge below didn't do. And there is a problem with that. You see paragraph 100 to 101. Ms. Hannett relies on further information provided to the claimant by the CSCMC, and it's quoted. And you might see there's some similarities between that and this, except it's not what happens there isn't necessarily evidence of what's right here, but this has been reviewed and will ensure that a suitable association group is created. That was generic in nature and didn't provide genuine and meaningful disclosure of the CSCMC's reasons in sufficient detail to enable the claimant to respond, etc., etc. Then throughout in paragraph 101, thus with the limited exceptions identified above, throughout the period to which these proceedings relate, and even at this stage, the claimant has not been provided with adequate reasons enabling him to make representations regarding his continued removal from association, etc., etc. And then halfway down, I accept Mr. Squire's submission that the administrative burden which is assessed by the defendant, the provision of adequate information would create, is outweighed by the importance of procedural fairness, as explained in Borgas. And then the conclusion, having regard to such reasons that have been given, it's unnecessary for current purposes for me to resolve disputes of fact. Had appropriate reasons been given, any potential misunderstanding or unwarranted assumptions would have been raised and investigated. And I will come back to some of that, as I say, with ground 8, because a while is important to that. But that's all just an example of the proper application of the principles in Borgas through to Ramirez Sanchez to the facts of a similar case. I mean, it's different because it's not got the non-engagement point, it's about associations, but you can see the discipline which we say Mr. Justice Ellen Bogan is expecting, and that was given to her and that was pointed out in post-hearing submissions.
Yes, I was wondering about the timing. So the hearing in this case took place
April 23.
23.
Yeah.
This judgment in Awali, the hearing in Awali was July 23.
Yeah.
The judgment in Awali was September 24th, over 13 months later. Is that right?
It is.
When were you asked? You were asked for further submissions on Awali, were you?
We weren't asked. We offered them.
You offered them a gratuitous
Two-
further submissions.
There were two stages of further submission. One following a request by the judge for an update on the facts, and that's in the supplementary bundle.
Yes.
And then also post-Awali submission, that's also in the supplementary bundle.
But that was from you
Yes.
after the September 24th.
We said you need to have a look at this as well while we're there. Right. And I mean, both Mr. Wills and Mr. Granderson, you will notice were
Both the cases, yes.
so hence we all knew about it. Can I just make some other sort of brief points, which are slightly legal points, before I move into the facts? One is about, I am going to say at several stages, I suspect, that you need to focus on the actual reasons that are given by the actual decision maker. There is a bit of bleed, if I can put it that way, into looking at other evidence to try to understand what was decided and why it was decided. But one has to be slightly careful about that. I don't say any of that is inadmissible, particularly in the convention claim. But for example, a lot of weight is sometimes attached to the evidence of Mr. Worsman, who at various points was the CSCMC chair. But one has to be slightly careful about that. I'll show you that in a bit more detail later, but he's not on, doesn't appear to be on every meeting, and his witness statement is written for the purposes of litigation 2 years later. So 2 years after the decision making is done. So one has to be slightly careful about this. It's of course orthodox, it's slightly different between convention claims and common law claims. It's of course orthodox judicial review. We can go to it if necessary, that you focus on what was before the decision maker at the time rather than ex post facto rationalisation of decision making. So I can go to authority on that if we need to. But we do slightly need to be careful about it, even in convention claims, and I'm going to show you that in a moment. The other example, apart from Mr. Worsman's evidence, is there's quite a lot made of the Secretary of State, and they've put bits of this into the bundle, is reference to nomis records, and I will see what purpose that's put later, no doubt. Nomis, as my lords and my lady may know, is the prison information database, and it's the document. It's an ongoing document recording interactions with prisoners, and any discipline officer, any member of staff, in fact, has got access to it, although clinicians tend not to. But it's a discipline staff thing. But it is, of course, never provided to the individual. So it can't be a source of reasons that are communicated to him to which he can respond. I think there may be an example at some point one entry is read to him, but that's not part of the decision making. And also it's the wrong decision maker because nomis is local discipline officers. It's not CSCMC. So I'm just making a general be careful point. We do need to focus on decision maker and what the decision maker decides. And just can I flag that on the authorities as well while I'm there on the convention side? Because we've got Brewster in the bundle, and we've got another one in the supplementary bundle to the same effect. But if I can just show you Brewster at page 193, which is at divider, so tab 8. And it's a pension case in Article 14. Can I then just show you at page 209 what I hope is a relatively uncontroversial proposition. Paragraph 49. The question whether justification has been demonstrated must be assessed objectively. That's not to say, however, that the court, that's not to say, however, that the court should substitute its usual avenue of decision maker. Indeed, it may be appropriate to accord a wide margin of discretionary judgment to the conclusion of a decision maker, particularly where it's in the legislature that makes the choice and where the conclusion lies within the field of socio-economic policy. And we've already discussed that point. And then paragraph 50. The margin of discretion may, of course, take on a rather different hue when, as here, it becomes clear that a particular measure is sought to be defended, at least in part, on grounds that were not present in minds of the decision-making at the time the decision was taken. And then you've got a reference to the well-known misbehaving authority. The court's scrutiny is bound to be closer, and the court may have no alternative to strike the balance for itself. So, what's the position if a decision maker is not conscious or doesn't address his or her or its mind towards the existence of values or interests which are relevant? And then the court scrutiny is bound to be closer. So that's the point I covered in passing as we went through. And I'm asked to read paragraph 52 as well. Not accepting the full submission of Ms Mountfield without qualification. Obviously, if reasons are proffered in defence of the decision which were not present in the mind of the decision making at the time that it was made, this will call for greater scrutiny than would be appropriate if they could be shown to have influenced the decision maker when the particular scheme was devised. Even retrospective judgments, however, if made within the sphere of expertise of the decision maker, are worthy of respect, provided that they are made bona fide. I don't take any issue with any of that. That's just familiar convention case law on that.
It is indeed familiar, but what's its relevance?
It's when you're. I'm just introducing a slight note of caution, where my submission is your focus must be on the decisions that are taken and communicated, and there is a section of the decision form that contains the decision that you need to focus on, and you need to be slightly careful about supplementing that with, for example, a witness statement prepared 2 years later, and much more with things that do not reflect decisions by decision makers and don't reflect things that are ever communicated to Mr. Thakrar. So it's just be careful. Also, back to the point I made a moment ago, is when you're being asked to respect the judgment of the Secretary of State as expert risk assessor, be sure there is a judgment, because quite a lot of the time we're going to see an absence of reasons or a blank, and you're not going to be able to, you are going to be in a position in my submission where you say, well, okay, it would appear to be relevant that the impact is getting greater. You might be bringing about that which you are seeking to avoid. I would like to know what the Secretary of State makes of that. The Secretary of State may have expertise, and I may want to respect that or defer to it, but I need to see what the Secretary of State says in the exercise of that expertise, and we're going to say you don't have that quite a lot of the time, well, any of the time. Another just point to be clear about, which is the impact of delay. I am going to invite you in grounds 4 and 5. I invite you to go behind findings of fact by the learned judge. I do say that you should. I mean, I say that even on the traditional standard for an appellate court, I get home there that there isn't a proper foundation for the conclusion she reaches about the adequacy of reasons, or indeed whether there was a decision at all. I'm going to say there. I get home on the usual test about whether or not there is a proper foundation. But However, in this case, you have got the 21 months delay, and that does soften that test, we say. My learned friend says, doesn't soften it, either doesn't soften it or doesn't soften it, that's because this wasn't an oral evidence. But it's not an oral evidence case, so it's not remembering the demeanour of witnesses on oral evidence. It's not that kind of case. But it is, it's a different assessment, but it still does matter, because this is a case, oral submissions matter, oral evidence matters, and there are matters within this case, which they are matters of detail, matters where each of us put different slants on things. There's a lot of things to remember. It is right that I handed up a detailed speaking note of what I was going to say in my opening below, and the learned judge relied on that. But equally, not all of it was the subject of a speaking note. My learned friend's submissions were not the subject of a speaking note. My reply was not the subject of a speaking note. I gave a rather long reply that focused on a number of things that I'm now talking to you about. And there are things I say that on the face of it appears that the judge has either overlooked or misunderstood, because, and the obvious inference is 21 months went by and you can't remember what the matter were. So I do say that that is a reason why 21 months matters and why it softens the effect. I would also say very gently, in parentheses, with all due respect to the judge, it also matters enormously to Mr. Thakrar, who, you know, had a finding.
Of course it does.
Yeah.
So it should. What it comes to is, it's not a ground of appeal in itself, but it suggests that a brighter spotlight has to be shone on the judge's reasons.
That's absolutely right. And that's how I put it, my lord. I'm grateful.
I don't think Mr. Krasinski is going to argue otherwise.
No.
So I hope.
I'm grateful. And Mr. Thakrar has heard that, and I hope will take some comfort from that. I mean, I put this very gently, but the slight concern that somebody in his position then has is, I'm saying that this is a breach of my human rights and that it's ongoing at the moment that we're before the court. He feels, you know, it gets harder to say that it's a breach of convention rights if you're 21 months later, because you're thinking, if you actually thought it was a breach of convention rights, you would have handed down your decision earlier. And it just makes him, you know, you can see how the mind digs in, particularly if you've got a mind that ruminates given the opportunities that he does. I won't take you to it because it's familiar law and given what you've said, but you've got Haringey and Ahmed on overturning factual findings at authorities tab 9. You have the same material as as the learned judge did. Things like the atmosphere of the courtroom is one of the features there, and after 21 months, the learned judge loses that too, he said. Again, it's not an oral evidence case, but oral submissions do matter. So, well, now that finishes what I just wanted to make those points. I will go back into some law, but I wanted to just focus on some facts. I've dealt with a little bit of this along the way already. Can I just repeat a little bit of what I've already said, which is it's important in a case like this. You're going to hear a lot about, no doubt, things that Mr. Thakrar has done wrong, including you know, awful things. It's also important, given the opportunity to do it, that I humanise this a little. He is, we remember the human at the heart of this. He's 39 years old next week. He had a relatively, you know, unremarkable childhood. Grew up in London, then moved to Stevenage. Well-educated, intelligent man. And then I've made my points about Dr. Cressati, but I'm, you know, she's a senior person, and I just want to show you that briefly. I touched on it. I'm going to just show you the references and give you a bit of the other perspective. You can find her report in tab 3 of the supplementary bundle, page 53, which is page 53. And I would invite the court to read this to get a sense of who she is and her approach, because I mean, even things like paragraph 2 on page 53, where she says, I get in there, Belmarsh staff have made these arrangements, but he's struggling with it, because he was not happy to be assessed in an interview room with an overhead camera where the prison officer was sitting close by without soundproofing. So they chat and they come back in a different way. You can see the things that I'm talking about, which is, she's just reporting something that happened in front of her, and she talks about how that's impacting on him. But you see paragraph 6, 7 and 8, just note her qualification. She's been doing this for 30 years. Chair of Kenton Medway NHS Mental Health Trust, she's very senior. Paragraph 10, she finds him cooperative, strong impression of being open and thoughtful throughout, somewhat preoccupied with perceived injustices, that's a feature of his presentation. And notice feelings of injustice did reduce his ability to identify positive experiences, and then she refers back to the afternoon session with Dalmarsh staff, etc. So you get a sense of how he is from this, I submit.
Is she retired from major clinical work?
I think she just, I don't actually know. I think she might, I mean, she says she's got 30 years experience in providing risk assessment. I think she's still, I think she's still working. I don't know.
I read.
Right at the end of paragraph 8, she says, I continue to provide clinical oversight to the largest community treatment programme for high risk and personality disorder, etc.
Yeah.
Okay.
I mean, I mean, I don't know what the position is now. That was in July.
But she had a major job in the NHS until 2016. Yeah.
Some of the family background you can see is at page 56. Talks about, he's an interesting man, we say, and you can see things like, I'll just show you page 59, talking about the PTSD, references to suicidality, page 59, paragraph 26. I note that Dr. Shapiro, who's also somebody who supported the diagnosis of PTSD, you may remember that you may have picked up that the diagnosis of PTSD was a feature in the 2010 matter where it said that he was acquitted by the jury on the basis of self-defence, and one of the features of that, and the judge is entitled to say, we don't know what the jury had completely in its mind, but it's one of the features is you genuinely perceive threat because of the way your mind is affected by its condition, and there was PTSD evidence before the jury. Then you have, I just note that Dr. Shapiro is, I think there was a treating psychiatrist at Wood Hill, I think he's the person I referred to. So these are senior people and part of the prison service to some extent. Then you say this, paragraph 27, a diagnosis of PTSD or level of symptomology consistent with diagnosis has been provided by the majority of mental health provisions within the Mrs. Thakrar. She refers to a number of them, goes through that. And I wanted to flag page 66, paragraph 53. Now the reports refer to Mr. Thakrar being polite and respectful for the most part whilst on the CSC. Top of page 67. Mr. Thakrar's insistence that psychological work of whatever focus should be provided to him in a private space. This is understandable given the personal nature of his difficulty, so she was supporting what he was saying. Paragraph 55, that's where I took, he's got a good understanding of how his mental health symptoms are best managed and what are his needs. When he's settled, he manages himself best by means of contact with family and friends and plenty of distractions. Finds the gym helpful. When under stress, he becomes withdrawn and prefers to be left alone. Unfortunately, he finds frequent approaches by concerned prison officers to be triggering, and any increase in the number of officers in the vicinity to aggravate the situation. Paragraph 61. Paragraph 60. Risky scenarios violence are situations in which he feels trapped, physically or psychologically, so that's why he manages those as carefully as he does, in connection with him being in the presence of those who are hostile towards him. Fearful or hypersensitive thoughts being triggered on the basis of the prior behaviour of these individuals. And then 61, important to note that he's managed frustrations around moves, communication, changing rules, restrictions, and so on without recourse to violence. When aggrieved, he uses acceptable means to complain and address issues. Those are points I've made. She spoke to his mother, and then
Read, he has not, just the bottom of 68.
he has not issued verbal threats to harm others. My friend's going to say that that's not true, but that's in April 21. She then talks at paragraph 70. She's careful about this because you've got to be careful in how you assess somebody when Mr. Thakrar maintains his denial of defence. She says the index offence, paragraph 71, in my view, the index offences are likely to have had a significant traumatic effect on Mr. Thakrar, and this will have been compounded by the imposition of this very long sentence. So she's saying, you know, PTSD is having the impact and is reducing the behaviour that we're seeing. Then 72, there is now an accumulation of opinions that suggest Mr. Thakrar has suffered from symptoms of PTSD as a result of events that have taken place in prison between the years 2008 and 2011. I appreciate the concerns of HMPPS staff that NHS or independent practitioners may have placed excessive emphasis on Mr. Thakrar's self-report, and that there may have been a secondary gain for him in falsifying or exaggerating his symptomatology. Nevertheless, in my view, there is compelling evidence for Mr. Thakrar suffering distress as a result of a mixed profile of anxiety, low mood and intrusive symptoms of PTSD. I consider this cluster of symptoms to fluctuate in intensity and to have improved gradually as Mr. Thakrar matures. He's also made use of psychological input, etc. So she is policing what she's saying, and she's taking into account the concerns, and she's saying, you know, I see what you're saying, but this is my view, and as I say, it's a view that sits with the views of others. She then says this at 73, but perhaps become easier to discern what the triggers to any exacerbation symptoms and coping might be. Extended periods of isolation without meaningful distractions exacerbates Mr. Thakrar's underlying propensity to ruminate. These ruminations can result in what I would describe as tunnel vision in relation to an exclusive focus on negative experiences, some of which, but not all, he can do with a fairly modest nature. Prison officers' concerns of unpredictable behaviour lead to stringent unlock conditions with multiple staff in an atmosphere of heightened tension. You can see how temperature goes up. And then below that, I don't consider his complaints and legal challenges to be signs of heightened risks. As with a number of other prisoners who maintain their innocence to find themselves at an impasse, such legitimate means of challenge become the primary coping mechanism for handling their situation and maintaining a feeling of self-worth and purpose. So she explains that. She talks about the fact that he's had to cope with physical attacks on him. He's of course been paid substantial damages by the prison service for attacks on him. Managed that without violence. And then this at paragraph 76, she says, you know, she thinks he could be suited in category B conditions. However, having been in the CSC system for so many years, I think it was reasonable that he should be tested within mainstream Cat A prison for 6 months in the first instance. However, I think it likely that Mr. Thakrar would find a return to a prison where he feels he could attack the trigger of deterioration. Ironically, I think that the high intensity but solitary CSC regime is exacerbating rather than managing both his mental health difficulties and the associated concerns of the prison regime. And then I'll let you read the rest of that paragraph. Finishes with, I would expect the number of complaints to reduce over time in many locations. So that's where she is saying, open it up. And then you see, by the second hole punch in the middle of paragraph 77, can't do.
Just read the first sentence. 77.
77. In terms of treatment, whether Mr. Thakrar feels he wants to pursue therapy for PTSD is entirely a matter for him and should be undertaken on a voluntary basis. Mr. Brzezinski will take issue with that, no doubt, but it's conventional view of therapy. I do not consider it to be a prerequisite for progression. She says it's not ethical or appropriate for such therapy to be delivered in a CSC location, nor would I expect there to be any reason to justify the presence of 2 practitioners in the room or a discipline officer given the risk of that was the position at the time. And finally, she adds the comment at the end on page 73. I consider the current situation is rather unhelpfully adversarial in terms of the splits between independent and HMPPS practitioners, and there may be some considerable benefit to a professionals meeting in which a range of key individuals come together to find a solution regarding the way forward. My experience working as an independent expert at parole board hearings, an oral hearing is particularly helpful when experts hold widely divergent views. An oral CSC hearing may therefore offer the best opportunity. And I think that touches a little bit on where my Lord
Yes,
just
well, that rang a bell.
So
How did the judge deal with this? Just, I know you're jumping ahead with this report.
the judge,
Quotes a bit of it.
yeah, I can show you what she does. I mean, she records it, but without much more. And if you,
I saw. I've seen the quotation from it. Does this report feature in her thinking, in her reasoning at all, in respect of any of the grounds?
no, not in any substantial way.
You say it should have done.
Yes, it's one of the reason why I flag it so much as it does. I just want to be clear, and I'll check. I'll just check what references there are, but it's I might just have forgotten one. But it's what I say is this goes to what you would expect the Secretary of State to have considered in terms of reasons. Because these are this is clearly a significant matter that's saying you might be making it worse and decreasing the chances of this happening. You're just building the impasse and it's going to carry on. And your ability to pull yourself out of the impasse is going to reduce. I don't know what the chances.
What's the date of this report? At what point was it before the Secretary of
It
State?
was before the Secretary of State on. It was served first on the Psychology Department in July 22. Which is when it was produced, because that was the route in. You'll see that the psychology department is the department that is obviously often represented at CSCMC.
To what extent, if at all, was it taken into account, or was it ignored?
It's not referred to at all in any of the decisions. And then it has also been sent to the Governor direct at Belmarsh in November 22, I'm told. But it's not referenced in the judgment.
You accept that insofar as it was taken, it should have been taken into account, it would have been taken into account with a number of caveats, which the Secretary. But your point is, it wasn't considered at all.
Yes.
And it was clearly information which should have been considered.
Yes.
Despite the fact that it failed to comply with the Secretary of State's requirements in a number of respects.
Yes. Yeah, absolutely. And it's just one minute.
Does Mr. Worsman deal with it?
Yes.
My Lord asked you whether Mr. Worsman deal with it, and there was somebody said from a sedentary position, yes.
Let me just see.
In which case it was taken into account, wasn't it?
But it's not in the decisions. That's the point. So what you don't see in the decision making when we look at the actual decision maker and the decisions that are communicated, saying we need to think about the impact of this.
So, as far as it is mentioned by Mr. Worsman, it's ex post facto, isn't it?
Yes. You just have a look at what Mr. Wilson said about that. You'll see that in the supplementary bundle at page 101, so paragraph 52, referring to the psychologists. So just before I go to that, Dr. Crossarty's report is set out in the judgment of paragraphs 121 to 125, but isn't dealt with in the ground. So it's recording that it's there without analysing it. And then you'll see Mr. Worsman says, paragraph 52, he refers to the sort of range of information that there has been available. And he says, whilst these external assessments, paragraph 53 on page 101, whilst these external assessments are considered carefully by the local management teams, they cannot displace the views of the HMPPS psychologists. And then they say they're trying to arrange different psychiatrists, but that's one of the psychiatrists who
Is the first sentence a description of what happened in this case, or a general description of what should happen?
That's very difficult to know, and it's also a reference to local management team, which may be the MDT rather than the CSCMC. So it's not clear whether it's being taken into account by the decision maker, and that's exactly the kind of question that we should be asking. And when you look at the decisions, there's no reference to it. And then
Well, was there any, when they were sent to the
No.
respondent, was there ever, thank you very much for sending this report, we will of
There's
course
no
take this
response.
into
I-
consideration in our evaluation.
And I've not seen that evidence. So I've not seen a response of that kind, but I'm not saying there isn't one, but I can't recall having seen it.
Are there, to what extent are there internal records which would show what has been taken into consideration?
Not that we've seen. And as I say, the importance here is the focus on the decision maker in the CSCMC. And
Should decisions in this context list the information which has been taken into account in reaching the decision,
should do,
not
doesn't it?
judgment,
Should do, doesn't
or
it?
any other decision?
You'll take us to the
I'm
forms.
absolutely going to
Is
do
there a
that.
space on the forms for the things, for the
Exactly.
evidence that has been
And-
considered by the CSCMC?
And what we're looking for in these purposes is, are you looking at it not just in the CSC, but in the DC within the CSC? And what you often see, what you generally see, is time after time after time. Sometimes they're missing.
Placed in the CSC.
So yeah, we're not. The objective of this is to move him out of the DC first. This is stage one, but he is what you normally get is suitably located at this time. He's not engaging suitably located at this time without distinguishing between. And I'll show you in the decision. You get that a lot, which is the mantra.
Location on the CSC and his location as a single unlock.
Yes. Sorry. Say.
But you don't see a distinction between his location on the CSC and his status as a single unlock on the
Almost
CSC.
never.
Yeah.
I know it's not helpful to be asked different questions from different angles, but can we go back to the first sentence of paragraph 53 of Mr. Worsman's report?
Yes.
When he says they cannot displace the views of the psychologists, were there psychologists' views available?
There is limited engagement. I might need to be careful about this. There are psychologists' views. You will see psychology referring to their limited interaction with him. There is some interaction. You'll see there are psychological welfare checks rather than assessments going on, and that's at various stages ably going on. He's cooperated with those, I think, but the intense work hasn't been going on, and so I think the view is being slightly careful because I'm doing some of this from memory, is that not engaging, doing welfare checks, we can't tell. Is essentially because we're not able to do it.
So when we read that sentence, what Mr. Worsman is saying is, although we carefully consider Dr. Crusader's report, it can't displace the views, or the limited views, which the psychologists have been able to carry out, or at least are recorded of carrying.
True. And what I think they're saying is, we're taking all of this into account, but we are not going to be satisfied of the fact that he's got PTSD, for example, until we carry out our own assessment, and we can't carry out that assessment.
It would help me to just look at that. Lady referred to the form.
Yes.
Let me just look at the form now.
I'm going to do an exercise when I go
I don't
through.
want to distract you, just so we can see exactly this being put into practice. What Mr. Worsman said happened.
I'm happy to go there now.
At
Just
some point,
but
in your
I'm
own
definitely doing the exercise where I'm going to go through a lot of them
Okay,
and
right,
show you
fine,
how
fine.
it shifts over time or doesn't.
Well, I'm still perturbed by the considered carefully by the local management teams, because he's not saying they're considered carefully by the CSCMC, nor is he saying how they get a report from the local management teams and consider that. The CSCMC
True.
deals with it themselves.
True.
But they simply seem to be taking it as read from the local management teams rather than exercising their own judgment. And I
True.
assume that the local management teams certainly have a governor on them, but also consist principally of prison staff.
True.
And that is the reason why
Yeah.
these were found, these decisions were accepted as unlawful, because the CSCMC had a governor on them at the time the decisions were made.
Yes.
So to the extent that they are relying on or simply accepting decisions of local management teams, I mean, isn't that wrong for the same reason that the local management
Yes,
teams have prison staff on them?
I don't think we-
They will do. And the CSCMC needs to be making decisions independent of prison staff.
True. And it's just back to it's not the decision maker. My lord, would you like me to go? I mean, I can show
No,
you.
no,
examples
I don't
as
want to
well.
distract you from your course. Can I make a flag up that it would
Yeah.
be interesting to see exactly what happened on the ground here, as opposed to the general statement of what
Absolutely,
should
we'll do
happen,
that.
Mr. Wiseman's statement.
I might jump ahead actually.
Well, no, don't. I have distracted you a lot, so don't.
No, it's
don't be
it's
led
all helpful.
astray.
It's all about this. There's So I think the only other points that I wanted to make about the history and the sort of the facts. So I just wanted to I've already also dealt with conditions of detention. Can I just, for your note, I mean, it's dealt with in our skeleton at paragraph 25, but can I also just show you his witness statement, because this isn't challenged, I don't think. And it was so within the witness, his witness statement starts at page 14 of the supplementary bundle, and there are various passages referred to in our skeleton. But can I just show you what he says about it at the end of paragraph? At the end is the final paragraph of his witness statement, which is page 52.
Sorry, where are we?
So it's supplementary
Oh, I see,
bundle,
it's supplementary bundle.
and page 52, paragraph
This
121.
is tab 2.
His account of, I mean, he gives an account throughout this witness statement of what his regime looks like. But then he says this,
Paragraph.
121 on paragraph 52, page 52 of the supplementary bundle. And I'll just let you read all of that paragraph.
Sorry, it's not page 52, it's paragraph 52.
In paragraph 121 on
Page
page
52.
52.
The last paragraph.
Last paragraph.
Just that.
Yes.
Unsurprising things. Just also on the facts, because I talked about it and my only friend places a lot of weight on it. Can I just show you the compact, this consent form that's said to be wholly unreasonable? That is at page 428 of this bundle. And you can see from the end, it's a long document, it's dated 20th of October 2019. This is something that he put together. And it is, my submission is that a lot of this you can understand and reflects his state of mind, and reflect somebody who is very mistrustful, believes has reasons for being very mistrustful, may be right about that, and is also very, very guarding of his own mental health, and what might be triggering, because he doesn't want to be triggered with consequences that may have. And you see, for example, he's saying the psychologist must agree, paragraph 3, sessions will always be on a one-to-one basis in fully open conditions without anyone else present or in earshot. Paragraph 4 doesn't want breaks. I will object to all interruptions without anyone entering the room without both of us agreeing. If the psychologist feels this means at paragraph 5, they need to ask a question about our session location. I will ask you which officer you should approach. If someone tries to speak to me about you, I will avoid it in the hope of not being prejudiced against you. Again, he doesn't want psychologists taking views from people he doesn't trust and thinks may be out to get him. He doesn't want paragraph 9, he doesn't want the psychologist who he's working with to be performing staff supervision for the CSC, because he doesn't want things from him leading into the management of him, the confidential matters. And also the reference at paragraph 13 is the one that I said, which is, whilst we're working together, unless you specifically request it, psychologists will oppose any attempt to have you transferred to another CSC location. And I can understand that, you know, that looks like it's very controlling, but at the same time, he doesn't want to have his therapeutic relationships, once he's invested in them, broken off. And at least from a therapeutic point of view, to have that said, look, that's not going to be very helpful if you move him again. Then you've got other paragraphs that are about confidentiality and information, the points that I made about if I say something. So on page 431 at Roman 4, you know, you can share information with prison authorities, but he wants things in principle to remain confidential, and he wants things to be discussed with him first, so you can correct things. So I understand why this is a long document, there's been a lot of time into it, and it looks like he's trying to control the term, but it's also, you can see that it comes from a place of mistrust and care, and he wants that care to be taken. Now, can I just now look at some of the justifications before I get into the decisions themselves? I can do this, I want to do this fairly lightly because I'm watching the clock. And also I'll do it from the judgment. So the judgment is tab 9 of the core bundle, and if I just show you paragraph 60, how this starts. If you wanted the bundle, it's in the bundle as well, but this is a convenient way of doing it. And you've got paragraph 60, page 121. And just see what's being said about the reason. This is where it starts on the 7th of April 2021. So now nearly 5 years ago. And you can see that the decision is then expressed as being paragraph 2 there. Your continued non-engagement with the multidisciplinary team, including chaplaincy, gymnasium, clinical team. Then you have the reference to the threat to a prison offender manager. It refers to, I think, a third party, saying you can only be a certain level of stupid before you need to have someone put a fist in their face, you'll not learn any other way. So that's what he said to have said there, that's what he's recorded as saying there.
Disputed.
No. I don't actually know, but I assume it's recorded. But the context is important. Then you see the next reference is affected the progression of the other men on the unit. And those are the three reasons that are originally relied on. If you then within the judgment turn over to paragraph 70 on page 123 in May 21, it's essentially the same thing. Non-engagement, threat, finding psychology sessions, actively influencing other prisoners in a negative manner. We'll come back to that.
Well, that makes reference to threats. What's the what?
I don't know.
What are the other threats?
I don't know.
And there's the indirect referred to in the original letter.
I don't know. It's not been. It's not been particular. We don't know.
Anyway, it's plural there.
It is. You're right, and we don't know. I do just want to emphasise this because in paragraph 71, he then moves to Belmarsh, and I just remind you, you may pick this up. This was an action that he was bringing for damages for breach of convention rights, which was essentially a failure to protect claim because he had been assaulted and/or there were threats to members of the family as well in various parts of the CSC. And it's a claim that he was pursuing, but what happened is it was set down for trial in October 2021. I can give you a reference to that if we need it. It was set down for trial in October 2021. He was transferred to allow him to be produced at Central London County Court, or how this was going to be done, in October 2021. But the trial was vacated in September 2021, and the proceedings were gone by 2022, and there was ultimately a settlement of quantum. And what happened is, I don't need to go into the detail of it too much, but the Secretary of State failed repeatedly to comply with disclosure
Struck
obligations.
out, and relief from sanctions refused.
Relief from sanctions
The
refused.
issue was quantum.
And they became quantum, and then that was just settled in another negotiation. Now, the point about I just want to make about this is this can't be, and certainly not for very long, a sensible reason for keeping him in segregation.
Sorry, my mistake. Did you say January 21?
22.
22.
Sorry. 22. Yeah.
Claim settled.
Yeah. So if you want to see SB 125.
I just don't got the date. That's fine.
January 22. That's when it, and then there was, following that, I think there was an application for, that was the strikeout, and then there was an application for, that was the application of the sanction, and then there was an application for relief from the sanction, and then that was dismissed. So there was, first of all, the sanction applied automatically, and that was the decision in January 22. Then the Secretary of State said, I'm going to make an application for relief from that sanction, and then that was listed sometime. Shall I show you the...
No, just do the date. When did the whole process come to an end, do you say?
I will. It was. The final order is 129, and that was in November 22.
Was his presence in Belmarsh required until that point, or not?
No, I mean there came a point where we were then I think in early 2023. He said, "I'm just going to stay in Belmarsh now for the purposes of." We were then very imminent on the trial before Mrs. Justice McGowan. So he did say in January 23, "There's no point in moving me. We are about to have these matters ventilated before the judge. Let's get these matters ventilated before the judge, and then we'll see, and that should inform any future management decisions about me," which obviously then took a lot longer than anybody anticipated. But there was no, he was only there to be produced for a trial. It was clear there wasn't going to be a trial from September 21, and certainly was not unless it was going to be relisted at some point. But from September 21, that had been that had gone, and then there are these sequence of first.
He was necessarily segregated there because Belmarsh doesn't have a CSC unit.
True.
It only has a designated cell.
True.
And segregation is implicit within the designated cell.
But it should not have meant we have to keep you in segregation now after probably September 21.
I understand that.
Yeah. And what my learned friend says about that in the skeleton is, I'm just quoting from his skeleton, it's at page CB 86, core bundle at page 86. I'll just take you to that. Is 4 lines down, it's unreasonable to expect the CSCMC to monitor the course of Mr. Thakrar's private law litigation, and it was open to him or his solicitors to draw any relevant developments to the CSCMC's attention. Respectfully, I say that's hopeless, just because at least people in the CSCMC know about the private law litigation because they were signing off and there's Mr. Stephen Betts, who was the CSC operational lead on the 21st of April 21, I think still remains the operational lead of the CSC, was signing off things like defences and applications in that case. But in any event, it's for the Secretary of State, who is a defendant to that action, should know what is going on with that action, has many opportunities to do so. And that we don't, in fact, know, Mr. Thakrar doesn't know that this is what the Secretary of State is relying on at this stage, because as I will show you when we get into the decision, whilst there are references in the minutes of there are references in the minutes of those meetings to people going, what's happening with the case, it never makes it into the bit that's communicated to Mr. Thakrar. And I'll show you that in a moment. But so that,
if the whole purpose of his being sent to the designated cell at Belmarsh was to enable his, I mean, the CMC knew the reason why he was going there.
Yeah.
If that's the single reason for him going there, then of course they need to review whether that reason still obtains.
yes, well, I agree. And
Irrespective of who knew what about the civil litigation, you'd have expected them to make inquiries about the litigation, even if that was the reason for his going there in the first place.
yes. I mean, you don't have the documents before you, but if necessary, we can go to them and show you that a member of the CSCMC is signing off the documents because they're the instructing bit of the department that's instructing those proceedings.
Well, when he went there, was it always envisaged that it would be a temporary move for the purpose of this litigation?
Yes, I mean, there was a dispute. We said before the judge, and I don't appeal this bit of it, you can reach this finding on the facts. We said before the judge that there had not been, it was different solicitors representing him in those cases, although I appeared for him, I think as his counsel, but that I wasn't part of that process, but it was that the solicitors had said, we've got a civil trial coming up, can you make sure he's produced? And that didn't necessarily mean that he had to be transferred from Belmarsh, but the judge found he probably does need to go to Belmarsh if he's going to be produced. I mean, whether it could have been done remote. They never get to the stage of how they're going to do that. And you may see that they were already thinking they wanted to move him somewhere anyway from mid-2021. They were looking at moving him somewhere. And so then that comes up and then they move him. But yes, it's for the purposes of ongoing court proceedings in Central London County Court. But because there's an order made in September 21, which is then not complied with, they vacated the trial. And then it goes through the relief from sanctions process, and the Secretary of State hadn't made an application for relief from sanctions, and it was all, I don't need to go into the detail of it, but somewhat unedifying in the conduct of the litigation. That's how that ended up. Now, so I just make that point too, that that's not a good reason for maintaining, and definitely not a good reason for maintaining things at the rising scale of what was happening. And that means what I now want to do is to now show you some of the decisions themselves. And I'm going to take a little bit of time over this. They are set out behind tab 7 of the supplementary bundle.
Yes, page.
They start at page 131, but that's in March, so just before it starts. I am going to say, I invite the court to read all of these. I'm not going to go through every single one, but I'm going to go through quite a few to try and give you a flavour. And I'm going to start, if I may, with page 143, which is the first one, 3 days after the decision to segregate him. Can I just make a couple of practical points about this, first of all? The decision that the document that he gets, or in various stages, is the document at 143. There are also minutes that are created, and for this meeting in April 21, that is the document at page 137, although it's dated 20th of April rather than 10th of April. I don't know the reason for that, but that's the CSCMC, and quite often you will see that it's cut and paste from the minutes into the document. Not always, sometimes it's different, but it's, that's how you do it. He does not get a copy of the minutes. He got a copy of the minutes through the litigation. He doesn't at the time see it, so they're irrelevant in terms of they're evidence of what was discussed. They're not evidence of. They can't be the reasons because they're not communicated to him for the purpose of.
Why are they redacted?
I don't know, and it makes life slightly difficult because you'll see at page 137. Sorry, the name. I don't know why the names
It's
are
redacted because they're considering other prisoners.
I don't know why the names on page.
Oh, I'm sorry. So when it's 138, where it starts,
Yes.
the bit above it is another litigant, another prisoner, is it?
That's what I've assumed.
Yeah, that's correct.
What I don't know is why the
Redacting the
names
names
on
of
page 137.
And afterwards on
Silly
page
question.
140 as well.
I'm sorry, that was a silly question. I was worried.
Sorry, and when I said I don't know, it's because I don't know why the names are redacted on page 137. Because as I've said, I think the CSC operation lead was Mr. Stephen Betts, who signed the documents in county court proceedings. You'll also see that there's a chair, and Mr. Worsman was, you can see this in due course, but Mr. Worsman was the chair for some, but not all of the time. So I'm going to focus on the monthly review document. That's on page 143. And the way it works is you get input from the from individuals. So if you look at page 144, there's a psychology contribution. In this case, there's no submission from the Public Protection Unit. There's nothing from Mental Health. There's a unit staff report. Then that goes to him. He then gets the opportunity to put in a response, and that's at page 147, which on this occasion was given to him via a member of the independent, via a member of the Independent Monitoring Board. Sometimes you will see that it records things that he has said, and then you get a recommendation, which is the document on page 148. There then should be, but we don't have it, a feedback to the prisoner which contains the decision, because you make the recommendation and then a decision is taken. And for April 21, we don't have the feedback document. So we don't have a decision at all for that. And you can see that on this moment, shortly after he moved, it's a very short recommendation. Mr. Thakrar is appropriately placed within the CSC system and segregation, DC, here at HMP Full Sutton.
I'm sorry, can I just interrupt? We don't, in this part of the supplementary bundle, have all of the documents that were before the administrative court. It wasn't, so far as I can recall below, suggested as part of Malone and Friends' case that on the 7th of April, which is the time when the decision was made to move Mr. Thakrar to a designated cell, he wasn't informed of the reasons of the decision. We've got a letter that Malone and Friends will doubtless show you, and I'll be showing you, that spell out the reasons in some detail. If it is said that can I ask you to look by way of analogy to page 154 of the bundle?
Yeah.
Which is feedback to the prisoner from the CSCMC from April 2021. If it said that there's some documentary failing in relation to April 2021, that formed no part of the case below, and it may be that if it had formed, nor is it part of the written case in this appeal, if it's to be said that things have gone wrong for the first time by my friend, then I would have to go back and check to see whether there was anything in addition to the documents I've shown you that is relevant to that kind of submission.
I'm not making that submission. This is right at the start. He has been given the reasons for the decision at this stage. I want to show you how it starts because I'm then going to go on to how it goes on. But there is an issue because you will remember that the judge in very, can I just show you this, keep this open as well. The sections of the judge's of the judgment that we are concerned with in relation to these, what become grounds 4 and 5, are paragraph 156, which is which is page 137 of the core bundle, and 138, which is paragraph 159. Because what I am challenging here in my opinions is the conclusion that the two conclusions that the judge has there. And so if you got to the judgment, if you look at paragraph 156, she says the reasoning behind the original placement is set out in full in the letter of 9th of April. The periodic reviews were provided to the claimant and his legal representatives. He further received the weekly reviews, the monthly reports from the MDT, and his quarterly CMP reviews. The claimant has always made sure that he seeks information. He's always known, though not accepted, that his continuing placement was explained by his refusal to engage. Now that's the reasons conclusion that he comes to. You know what the reasons are. It's about not engaging. I am going to say that those documents, that the reasons aren't good enough in relation to this grant. But there is an issue in that the judge there refers to weekly reviews, monthly reports from the MDT and his quarterly CMP. The reason why we're not very interested in those, and I'm just taking you to the decisions, is because the monthly reports from the MDT and his quarterly CMP reviews are not the decision maker, and that's the position my Lady Justice May. So I don't mind what they say because they're not. I don't think we don't have them before the court, and I'm not sure anything was made of them below because they're not the decision maker. They don't contain. Nobody suggests they say anything additional anyway. The weekly reviews, I genuinely don't know what those are. There's various references. Sorry, yours.
Sorry. So what?
Yeah.
I mean, the concluding sentence. You may criticise the judgment below in certain respects, but the last sentence of 156 is the heart of the case, isn't it?
Yeah.
You say it, his refusal to engage was for good reasons, which you've explained in some detail, and the onus was on the Secretary of State to resolve the impasse. I don't understand why, looking at what this monthly review meeting decided, or what the other monthly review meeting decided, or what degree of explanation was given to the claimant, adds to or subtracts from this central point.
I am going to say that when you look at these decisions, they do refer a lot of the time to non-engagement, and I say that over time, in particular, I'm not particularly concerned with April 2021,
No.
Because it's just starting. But I am saying that is an insufficient reason, and I'm going to show you whether there's anything else in there, and to the extent to which non-engagement is said in each of those individual decisions. So I'm making, when the judge says it is enough for you to have known at the beginning and various other stages that non-engagement was enough, I'm going to say no, it isn't. That's my submission. And I'm going to show you, sometimes that's not said at all. It is said, and even to the extent that it is said, it is not enough to have that and nothing else as time
You
progresses.
accept non-engagement. You obviously do accept non-engagement is a factor in any
Yes.
decision.
Yeah.
Is it a constant factor, or does it fall to be re-evaluated as time goes by?
It calls for re-evaluation as time
Depending
goes
on
by.
what?
Depending upon the circuit, depending on the impact on him, depending on what other behaviour you're seeing, depending upon whether it's supplemented by anything else. There are various references at various stages that it's really about the civil proceedings, or it's really about, he's inciting, he's being difficult to malign influence on other prisoners, those sorts of matters. But it is not enough. The judge was not entitled, we say, to come to the conclusion that it's enough to have been told, particularly at the outset, you've always known non-engagement. And I'm going to show you what else is there as we go through, and when it's not there. It's also, can I just make the point of paragraph 159? When you are making, the point here is, the judge has been satisfied that consideration was given to the second question, i.e. segregation or not, on the basis of records of the CSC meetings. My learned friend says that's got to be based on what CSC meetings actually considered, which is either recorded in the document or recorded in the minutes. And I accept that the minutes could be evidence of what they actually thought about, although I would have a reasons decision if it didn't, reasons challenge if it didn't make its way into the conclusion. But I'm just flagging there that the records of the CSC meetings are these two documents each time. They are either the document itself or the minute. Can I also just, while I'm there, however, express this? If you look at the one that we're looking at, which is page 143, I made this position a couple of hours.
Okay. In
supplementary bundle, so back, 143. Our understanding on the appellant side is this is the document that the people who are completing the report see. 143 in the supplementary bundle. Page 143. Where it sets out, so it's inviting the reports that it invites, psychology, unit staff, etc. Purpose of the monthly review. I don't make much of this point, but I make something of it. Prison Rule 46, paragraph 1, provides the authority for placing prisoners under Rule 46. 46, paragraph 2 requires the placement to be reviewed monthly as follows. Then the monthly report is intended to provide the CSC with an overview of the prisoner's behaviour. The monthly report must contain up-to-date relevant information to aid the decision-making process. Specific targets are contained, and then any targets of particular note should be detailed within the body of the report. Multidisciplinary attendance, etc. What this doesn't do is direct attention to those writing reports to the second question, which is segregate as well. So there is, when I get on to go back to Awali Underground 8, I am going to say that if you look at Rule 45 and the accompanying PSO, the guidance that accompanies it, that is a better protection on segregation because that expressly directs attention of those who are doing the segregating to the question of segregation, and this doesn't.
Which document does?
When you segregate somebody under Rule 45, there is a prison service order which says this is what you're doing, these are the things that you need to consider, and it essentially gives what Borgas says it should give, which is you need to give meaningful reasons. You don't have that, and as Mrs. Justice Ellenbogen says below, that's not done as well in Rule 46. It's much more sparse as a system. This is my ground 8, I'm bleeding into my ground 8 now, but it's made good by this, because it's saying the Rule 46 arrangement never seems to have been set up properly in order to focus the attention of people not just on placement in the CSC, but the second question of segregation within the CSC. And you see a bit of that when you actually see the document they're being sent, which is it doesn't say segregation anyway, it doesn't say also think if they're segregated.
On the contrary, right at the top, where it's recording what his risk status is, it has him on mixed unlock.
Yeah, that's true.
Was he on mixed unlock at that time? Because if he was on mixed unlock, then they wouldn't need to consider the continuation of the segregation.
I assume that's
indeed, the form does seem to identify the difference between routine mixed unlock, restricted single unlock.
Yeah, I don't know. It says regime risk status has mixed unlock or singular unlock, but it was.
Mr. Brzezinski's shaking his head.
He had been on mixed unlock. He's moved to mixed. He's moved to what amounts to single unlock. And if you look at all the other forms thereafter, they all identify that he is on singular unlock. So if you look, for example, at 159 in the box, or 149, 149 is May,
Yes, and there he's recorded as 2.
and then likewise 159, etc., etc.
He's not on a mixed unlocking maybe, is he? I mean, the point. We'll get into these documents a bit more. And my learned friend's case, and this is where we divide, is you can assume that because they knew where he was, you could assume that when they said suitably located or appropriately placed, they were thinking about both questions. And I say that that's not good enough because you need the focused attention on both of these questions. Do you need a CSC? They're always answering yes. Do you need segregation? And I say it's not helped, as my lady is accepting, is that the form doesn't direct you to think about it. And you know, the court is familiar with structuring decision making and the importance of directing report writers to think about the things they need to report about. And this seems to be a form that's designed only to look at the 46.1 question and not the separate segregation question.
Is there any chronology document anywhere? I ought to know, I haven't seen it.
There is a chronology.
Date X, he's put on to single unlock. Date Y, he's moved back to unlock.
There is, my lord, there is one on page 106, but I'm afraid it's not. It's been done in a relatively brief way, so it doesn't have the it doesn't have the detail I think you're looking for. As I address you on these things, I am working myself from a table of each of the decisions, of which there are about 24, because it's 2 years. If you would find it helpful, I might be able to overnight convert that into a thing so you could look at each of these, but otherwise it's reading, it's got page references, otherwise it's just reading each one of these.
Can I just, I know again, apologies for it's another angle.
Yeah.
So the process is someone prepares this monthly report.
Yeah.
And that goes to the committee.
It goes to him first, and he gets the right
That's
to
what I
make
wanted.
representations.
So
of that.
you have his report.
Yeah.
You're looking at the
So
first
you
one.
get sort of page.
Feedback. It's best done actually in the later one, the next
Yeah,
one,
it is.
I think. So if you go to page okay, this is what we looked at.
Well, so if you look at 159, for example, and then you've got the
Yeah.
feedback at
So-
163.
Okay, so 159. Yeah, well, that's what the one. Look at the second one.
Which page?
152.
And that writing is his, by the way. So we're partly getting these from
So
him.
submissions given to Mr. Terry by the appellant.
Yes.
This is after he's got the report.
Yes.
And these are
Well, he's saying in it he hasn't yet received a copy of the report.
okay. But that's so there's the report,
Yeah.
his comments report, and then it goes to
Yes.
the.
And then the recommendation is made, and then and then the decision is made, and that comes back to the
Where do we see? Going back to the point we made earlier, supposing that they have a psychology report to be produced, where would we find that? Should we find it recorded? We shouldn't find it recorded in the necessarily in the report. It would be in the minutes.
You might get it in both. You might get it in the psychology recommendation that feeds in, or you might get it in the minutes.
Is it your case that in nowhere in either the reports or the minutes of any of these decisions do we find a reference to a report submitted independently on his behalf?
True. I mean, I'm now want to check again just to make sure I haven't missed it. But true.
Okay, standing there and you'll check the amount.
Yes. So because yes, I think yes. I mean, there may be a passing reference, but I don't remember seeing one, and I don't think there is. It's definitely not in one of the concluding decisions. When we think about this, because they take the view that you've got to be one of our psychologists for us to carry a proper way.
On page 150,
Yeah.
of the unit staff report,
Yeah.
towards the end of the month, his behaviour improved and his unlock was reduced to level 1, which is mixed unlock. However, his interactions with staff remain minimal, and psychology reports that he's still not meeting with them.
Is that
So he's still not engaging, and he's been transferred into mixed unlock.
I don't know the answer to that, my lady, off the top of my head, but he's I don't know what that can possibly mean.
I'm assuming it means that he was moved to mixed unlock because his behaviour had improved in 2010 when this report was done.
2021.
Sorry, yes.
Yeah, he remains within, but you can see in psychology, as DC individuals,
But,
still.
I mean, my point is that to the extent, if that is right and he was moved to mixed unlock, then he was still not engaging at that point, so that really wasn't a sufficient reason at that point for him not to move to mixed unlock.
I need to check the detail. I need to take. I don't know what happened there. I mean, he's.
So the reference to unlock, my lady, is to the number of officers who are necessary
Oh, yeah.
to unlock him from his cell without
Oh, I see.
without
So
compromising their safety. So
so
sometimes he can be
status-
unlocked.
So when they say regime status, routine mixed unlock is with singular unlock.
Yeah.
It's actually the other way round.
The- the-
Singular unlock is
I'd have to take instructions about what the reference to unlock means in on what pages, but sometimes it refers to how often mixed and single, as I understand it, means can you associate with. If it's mixed, you can associate with other prisoners. If it's
Yeah.
single, you can't.
Yes.
But there are other references to unlock, which is how many officers need to enter the cell to be safe because of the risks that you present at the time.
it can't mean that here because his unlock was reduced to level 1, which is mixed unlock. If
No, I'm
that
not
would be increased, if mixed unlock there referred to more prison officers
Well,
needed, wouldn't it?
I mean, if you look on page 149, above the upper hole punch, there's regime risk status. Above that is unlock requirements.
4, yes.
4. I'd have to take instructions, lady, about what precisely that passage at page 150 refers to.
Well, it seems pretty clear that it refers to level 1, regime risk status, routine mixed unlock.
I'll take instructions.
Okay.
I don't know how.
There's another term, back wall unlock. I don't know what that is.
Which means you make him stand against the back wall when you're.
Before you unlock his
Yeah.
cell. But I think we do need to know what that means because if he has even temporarily been changed to mixed unlock, then because his behaviour's improved,
I don't know.
then it raises questions about the sufficiency of continued non-engagement as a justification for him being kept on single unit, isn't it?
Yes, and well, I can't give evidence. I mean, I think these things may move a bit on the ground, and it's.
I'm sure they do.
Can I just? I've made the point about how the document works. Sorry.
All I would say is you have to read that sentence together with on page 150, together with the previous sentences. Partway through the month, he made threats on multiple days towards staff, resulting in him being placed on back wall unlock. He was, however, compliant with instructions when moving around the unit during his period. Towards the end of the month, his behaviour improved and his unlock was reduced to level 1. So I just, one might think that the
You're going
inference
to
is,
check what that actually means.
Yeah.
Certainly by the time of the next report, he's on.
Strong, how are we doing? 20 to 1.
I'm a little bit worried about time, but I think I think I'm all right for 3:30. Can I then just show you how this, the last sort of 20 minutes before lunch, you then just notice on page 153, you get the recommendation. Sorry, if you look at what's this? Yeah, if you look on page 148, this is the April recommendation. Mr. Thakrar is appropriately placed within the CSC system and the segregation DC, so it's got the double consideration. We don't have the final document. I'm not making much of that at this stage. It's right at the beginning. Can I just, however, just point to the minutes about what's being discussed here, which is at page 139. if you look on the halfway down the page, on page 139, you again went through the following points of the defensible decision meeting. Very complex and challenging, was not engaging with the staff on the unit, will engage with the regime but not services. On the 2nd of April, made threats to a member of staff, but that's, we think, despite the plural, it's the probation officer, we understand. Meeting was already arranged. Defensible decision documents are best suited in a DC at this time. However, he will at some stage need to be moved to a unit. So they recognise in that, it's not in the reasons, but it's in the minutes, that this can't be forever. Whilst remaining with that recommendation on page...
Again, I'm sorry, John. The reference to his solicitor making representations in the next sentence. So there is a process by which, in addition to the passage, the form where he is responsible as well, there's also scope for other representations on his behalf.
The solicitor is sometimes there.
Thank you.
So he attends remotely, is my understanding. I understand that. Can I just check that? I think that he attends. It might be that he's attending the CMG.
Sorry, David. to interrupt. I noticed that on page 139 there is a Word document in.
I don't know what that is.
Is
Sorry.
that the letter? Possibly. Yes, it must be. That's the letter from the solicitor, isn't it?
I don't know. I don't know without checking. I'm afraid my
That's what it looks
solicitor's
like.
not
Letter attached
informed.
below.
Sorry, I'm being told that my solicitor doesn't attend CSCMC. There may be. I think there was another meeting that he attends,
Okay.
but I don't. But I'm being told it's not.
But
this.
that document shows that he sent a solicitor sent a letter which was considered.
Yeah.
That's what it says. So have we got that letter?
We don't. If we then go, can I just, these are small points, I need to slightly speed up a little bit. So you get the decision on you get the recommendation but not the decision on page 148. Can you just notice that the following month, which is May 21, you get the same recommendation on page 153. And Mr. Thakrar has written at the bottom of 153 that it's a duplication. You can see it's the same date, the same signature. And then you get the feedback, which you didn't have the month, or we haven't got the record of the month before. And you can see that the conclusion of that feedback is the committee agree that Kevin is currently appropriately located, and Kevin should make every expert, including the change of psychologist, while he is segregated. Now, I'm going to jump ahead now, if I may, because I can't do every decision, to July 21, and you see the decision there at page, and these are just the most I can do is samples of this to see whether the judge was entitled to come to the conclusion that she did. 180, page 183, you see the recommendation. Kevin's compliant with the segregation regime but declines to interact with officers. We continue to recommend a transfer to another unit as there's no healthy interaction from him here with any agencies. Additionally, continues to impact others on the unit. His CAT-A review is due in the near future. Then we're into 184, which is the decision. Doesn't interact with governors during their daily visits, little in the way of interaction with others, does continue to use the facilities available to him, including the exercise yard, does not engage with the CSC process, and as such we are unable to fully assess his risk. He is appropriately placed at this time. And my learned friend invites the court to conclude that appropriately placed means they're considering both things, but you don't see the decision saying that they're aware that where he is, but they don't see the focused attention on the two separate stages of that decision making, and they don't give much in the way of reasons. And I say that from there we're now heading in to quite a lot of the repeat of that formula. The next decision is on the next page, 185. But that's now August 21. And he gets a recommendation there because but that's when he's now gone to Belmarsh, transferred to another DC in a dispersal establishment. Continues to not engage, didn't present in a threatening manner, but did encourage other prisoners to not comply with the unit's regimes and rules, which culminated with a female officer being brutally attacked. He continued to submit ridiculous amounts of complaints, and I think that's discrimination complaints. I forget what the acronym stands for, which all demanded that staff was thrown out of the unit and he received apologies and compensation. Overall, another dire reporting period. See, the next page is the feedback. He was seen as influential over the other prisoners in the segregation unit, encouraging them not to engage. He was heard in the yard encouraging others to assault a female member of staff. Just because my learned friend goes to this, can I just show you page 350? It's not pleasant stuff.
Sorry, which page?
Page 350 of the supplementary bundle, but it's just making the point that there are different accounts of what happens here. Because if you look at this, this is in the nomis entry, which obviously he doesn't see at the time, but in fact, what it seems to be, I mean, I don't take which of these is true, but what in fact seems to have happened is he is saying that the female officer is racist rather than inciting other people to attack her. So that's a reason why one needs to put allegations, because they're put differently in different places. So that's page 350 on nomis. But if you then go...
Sorry. Isn't that a friend?
Mr. Brzezinski,
Okay.
you're very experienced, and sometimes it's justifiable to intervene, but this is turning into a bit of a committee exercise. If Mr. Armstrong misses out something which is essential for us to see, then say so, but otherwise letting it on.
Thank you.
Yes, Mr. Armstrong.
So I'm going to try and do this by samples. You then, on the feedback at page 189, you're seeing a slightly different account of that. You're seeing references to his politeness. You're not seeing a decision based on that justifies his segregation in that decision. Can I then, September 21, you move to page 197. We have the minutes of the decision, we have the minutes of the meeting, we don't have a decision document at all. I don't know the reason for that, but it's the submission below is when worked through this, there are things missing, there are reasons missing from various sections. How can you be satisfied that this decision was A, taken, and B, taken properly? It's obviously not helped by the decision itself be missing. And the same is true of October 2021, where you have minutes at page 201. Ignore, I think, the fact that it's 18th of October 22 there. It should be 21. That's why it's where it is. But again, we don't have the decision document. That's October. I'm now going to jump ahead a little bit and show you page 215, which is the November 21, sorry, the December 21 decision. So now we have got a decision again. Recommendation is at the bottom of 215 blank. Over the page, feedback to the prisoner from the CSCMC blank. trying to work out what they decided, look at the minutes at page 218, and this doesn't count for reasons because it's not sent to him. He has left the review because he was unhappy with somebody who was present, stood up and left the room. But there's nothing there that suggests the decision was taken. So when I'm saying you need to have a decision and you need to have reasons, I'm getting no help from the documents here, and I'm just propping up the submission. I say, when the judge says there was a decision, and I can see from the records, well, some of the time there definitely isn't. It's then January 22, you see, that starts at page 220. You see he's put in some brief reps at 222. The recommendation is blank. The feedback is there. Talks about his behaviour being consistent. He's still submitting complaints. CMP to be arranged for next month. He's not happy that he's only receiving welfare checks for psychology, hence his non-engagement. There's no actual decision or reason recorded there. And we go on, February 22. At page 232, completed by the recommendation. He engages with the MDT and he remains appropriate at all times. He's
Which page is that on?
232. Mr. Thakrar is keen to progress at the earliest opportunity, so he engages and he remains appropriate. I mean, I would say throughout this period he's an enhanced prisoner, and the court may know what that means. Mr. Thakrar is keen to progress at the earliest opportunity. A plan to move forward would benefit Mr. Thakrar. Feedback to the prisoner, box is blank. March 22 is at page, the requisite bit is at page 238. Recommendation to the CS, the recommendation is blank. There is recording of his complaining about being a CSC in the feedback. He doesn't actually say what the decision is, still less any justification for it. Like the staff would have to be informed of any move, so that doesn't contain a decision. And can I just point out that at that point, that's now March, we're now approaching a year with this. But it then gets worse because you go into April when it is a year. Page 241. Recommendation to the CSCMC, blank. Feedback to the prisoner, blank. And I can, there's a lot more of this. Sometimes you have more in them, but in July is page 265. Complaining in the recommendation, if he was to begin to engage in the wellbeing sessions, that would be satisfied longer-term pathway out of Belmarsh. Feedback to the prisoner from the CSCMC. Feedback to the prisoner is blank. Can I just point out here, that if you look at the minutes, just to see what they were, see if you, again, they're applied to him so he doesn't know what's being said, so he can't respond to it. But if you look at page 267, the minutes from July, doesn't attend his monthly review, decline and complain about it. Recent court case, Belmarsh can't find anything booked for this. Well, that's because that court case wasn't happening by then. And it was, but he's not been told that. We could have corrected that if that really was the issue. But as I say, people on this committee absolutely know. August is at page 273. That's where you do get a decision. That's why I flag it. But he's been in there for a year and 4 months. And you see at page 278, there's no recommendation. but at 278, he's located in a DC at HMP Belmar. Fluctuations in his level of engagement. He's suitably placed within the DC and as a Rule 46 prisoner, as outstanding targets on his CMP. And there are avenues to explore around increased engagement, which the local MDT are trying to take forward. So they're saying he is suitably placed, but they're not dealing with civil proceedings, they're not dealing with how much time has gone on, they're not dealing with the impact on him, they're not saying whether or not the August 21 allegation against him involving a staff member is still relied upon. It's just, you've got this impasse, he's suitably placed, he's not engaging, that's where you stay. And
No,
that's
he's not attending review meetings.
yeah, well I mean, he says things, he puts in his reps at 276, but he doesn't want to engage with them. And I will see if I can just finish this part of the exercise before the short adjournment. I'll just show you page 293, please. So this is the October 22, page 298. There's expressly no recommendations. He's appropriately located as Rule 46, no separate consideration of segregation. And then the feedback, he has outstanding targets on his CMP, which is to engage, and we are unable to fully assess his custodial risk. He is to remain in the CSC as a Rule 46 prisoner. Again, not separated out and doesn't deal with the other matters that we say should be dealt with. Page 303 for the following month. Again, so page 3, so the actual bit is at page 307. There are no recommendations made to the CSC due to lack of engagement. He's appropriately located. And then again, 308, he's appropriately located as a Rule 46. Again, no separate consideration, etc. January 23 is a page, just to bring us up to date, to when we only have 2 more from January. January there's 3 more, but I'm just summarising. But January and February 23. Again, on page 324, no recommendations made to the CSC due to lack of engagement. 325, no alternative options at this stage outside of the CSC estate. So again, this is now the mantra, it's now becoming formulaic. No separate consideration, single line or so, line or 2 in response. And finally, the last one we have a record for, February, currently no recommendations. So this is page 338, I'm sorry. Currently no recommendations, and then the feedback, he continues to reside at Belmarsh at his request for an upcoming court case. It's positive for Mr. Thakrar that he chose to attend his last CMP. At this time, Mr. Thakrar continues to refuse to engage with the psychology team, which will assist us in identifying his custodial risk. As such, no reduction in custodial risk, and needs to remain Rule 46. No separate consideration. I'm not sure whether that feedback is because by then he has said, look, I've got this hearing in April, leave me where I am until that's concluded. I think that's probably a reference to that rather than to the county court proceedings, but I don't know. But again, you get the picture of when I am looking, as I've said all morning, for care and attention and addressing the matters that they need to address. And my submission is, you don't get that when you look at these decisions. You just get this, what becomes certainly the recitation of this rather formulaic response that says, you're not engaging, we don't know, stay where you are. But without analysing both limbs and without giving reasons to address the matters that we say are relevant. That brings me entirely to 1 o'clock, and I'm going to go into my legal submissions for no more than, I hope, an hour and a half.
Yes. Right.
We'll see if we can get some answers to some things, either or maybe overnight.
If either side is going to leave a point to Mr. Wills and a point to Mr. Grandison, we will of course be delighted, although it's not compulsory.
Look of overwhelming enthusiasm from the audience.
Two o'clock.
Court rise available.